um, I won't ask you any questions. We'll just continue on. Because sometimes we go over because I talk a lot, so I'm going to warn you right now. I always go over. So how it'll work is I'm going to start the course. Rex will come in during the center and talk about the accounting portion, and then I'm going to come back and talk about the petition. So you will hear both of us interject, come in. We encourage you to use the chat unless we open up and ask for questions, just so we could keep the meeting moving. Again, both of us will stop many times during the meeting and say, do you have any questions? Is there anything that we could further answer? That's your time to jump in. I will be trying to watch the chat, but typically won't interrupt either Rex or myself with the chat until we get to that stopping point. Otherwise, both of us will forget where we even were when we were talking. So we're going to get started. Welcome, everyone. And I'm going to turn the talking points over to Rex, and I will jump back in once he's done.
Okay, greetings everyone. Welcome to the court accounting course. My name's Rex Crandell. I'm a CPA attorney in Walnut Creek, California, and my colleague here is Tamara Brown, who's a tax preparer, but more importantly, a legal document assistant in the Napa, American Canyon, San Francisco East Bay area, and I'll let her introduce herself when she comes on. We've been teaching this class for probably 7 or 8 years, I can't recall. We started it and got it approval from Judge Sugiyama because it's offered by the Contra Costa County Law Library. And our objective was originally to help pro per self-represented people meet the requirements of the fiduciary accounting. Since I've got a CPA background and I have an affinity, so does Tamara, bookkeeping background, that we wanted to help people figure out how to do this unusual accounting, because in all of the accounting classes for the degree, not once did they mention the word fiduciary accounting or give any examples or offer any classes. And our system here is based on the California Probate Code, and each state has its own little quirks and requirements, uh, but it's a unique system, and there's no license required for people to hold themselves out to the public to do fiduciary accounting, and it's done as a service by independents, by paralegals, legal document assistants, bookkeepers, uh, and obviously the executors, administrators, conservators. Um, Being that it's so unusual, some people think that when you get done with the court accounting, you can jump in and do an income tax return from the information. And that's not really the case. I mean, you can gather some of the information for income tax for the difference being it's a complete different set of assumptions for fiduciary accounting based on California probate code. And then when you take the same data and try to do an income tax return, the federal rules have a complete different system for example, depreciation and things like that. So we're only going to be covering the California part. The today's presentation will be divided into three parts. First, we're going to have Tamara Brown is going to go over how to create the original inventory and appraisal that the court requires for probate, guardian, and conservatorships. And then after the inventory and appraisal, I'm going to be covering the what they call GC 400 sum. It's the summary or cap sheet for all the accounting, and then go through all the judicial council forms for guidance, Then I'm going to show you an alternate method of doing it versus doing it on the government forms, doing it on a spreadsheet program. And that's another acceptable way to do the fiduciary accounting, but we're not going to spend a great deal of time on the computer generated forms because we get more educational information by following the state judicial council forms. After I get done with the grinding out of the data forms, then I'm going to give the presentation back to Tamara Brown, and she will guide you through preparing a petition for the court. The petition accompanies your accounting and you're submitting it for approval by the court, which is the requirement that you're trying to comply with. The class should be done at noon today, but sometimes we go over. It might end up being 12:30, 12:45. You're able to jump out if you have other things you need to do. So with that little orientation, I'd like to turn the program over to Tamara Brown to cover the section on inventory and appraisal and anything else that's relevant. I need to transfer the control of the meeting. If you'll bear with me a second, I'll make Tamara Brown the host and then she can share her screen with you. Okay, so the transition's been done. Hopefully now you see Tamara on the screen. And good, everything's fine.
Okay, all, good morning. Okay, so I'm going to start with the inventory and appraisal that needs to be done. It's a significant part of preparing an accounting. If the inventory and appraisal, which you'll see on my screen, is not completed and not completed properly, prior to you trying to start your accounting, you will never be able to get the accounting approved through the court, which is the ultimate goal when making an accounting or preparing your accounting and presenting it to the court for approval. Most of the time that I would see half, at least a little bit more than half of the reason that the accountings will be rejected by the court is because the inventory and appraisal was not properly done at the beginning. And anytime I am asked to prepare accountings, I have many years of experience. I prepare them for many law firms. I also review them for many law firms and assist preppers in doing this. So the first thing I start with is the inventory and appraisal. It's due on the conservatorships anyway. It's supposed to be turned in within 90 days of actual appointment or receiving letters. So it's done, and I'm going to go through real quickly how to prepare it and then how I use it to begin the accounting. So this is going to be a blank form. If you have not completed one, what you're looking for is right here up top where it says the form title. It is the DE, which means decedent's estate if it's probate, or GC, which means guardianship for a minor, or conservatorship. So either if you're in probate court, they will refer to certain forms by their form number. And so the inventory and appraisal is the DE 160 or the GC 040. So it is going to be blank. The first thing you're going to do is fill out the caption part. This sample is in the conservatorship handbook. that I encourage you to, at any time you have any questions, you go online. You can look at the book. If you wish to purchase it, it's a very expensive book. You still can print pages online, but it's hundreds of pages. So this is where the sample comes from. So this is completed as if a law firm completed it. So you would not include an attorney name here. You would just put your own name and address, phone number, email address. Please remember your email address. The reason why the court is asking for that email address is that if they need a way to communicate with you, like for some reason, maybe sending you your examiner notes or tentative rulings or anything of that nature, they will email them. So I strongly encourage you to include your email address, even though it states it's optional. Otherwise, you will not be informed by the court if they wish to communicate with you. Right here where it says attorney for a pro per, you would put your name, comma, and then the words pro per, PRO, space PER. They also use the words per se. So you would indicate that there. You want the court you are in, you will need to figure out whether it's Orange County, Contra Costa County, Napa County, any county court that your case is in, you wish to indicate here. And now we're coming down to this question. Even though it says a state of, that typically means a decedent. These are completed by, they are completed for probates, conservatorships, guardianships, and can also be for trust administration if the trust had to go through the court for whatever purpose it had to go through the court. Typically, that means one of the beneficiaries wants to use the court to ask the court to have the trustee perform a certain way or not perform or something of that nature. So just because it says a state of doesn't necessarily mean the person is deceased. So you will put the person's name here that you are, or who is the conservatee or the decedent or the minor. And you will mark the box that indicates what they are. Is it probate? Are they a decedent? Is it conservatorship? They're the conservatee. Is it a guardianship, which means minor? Or if it is a trust, you would just put the trust administration. You just put the whole trust name and not mark any of these boxes. Moving along, you're going to come down to the section, and there's two ways, typically many more actually than two, but that a pro per would technically use this form. They're not going to know many other ways on how to use the form, but you're either going to mark a partial, which means you're indicating to the court, this is not all of the assets I have. This is only a partial list of the assets. Or you're going to mark it final, meaning these are all the assets I have, there won't be any more. Or you're going to mark it supplemental, meaning you have already filed a final, but then located extra assets, so you'll mark supplement, meaning you're just going to add to the final. A corrected is if you turn in the inventory and appraisal and say you indicated the balance in a checking account was $3 and it actually should have been $23, you would mark corrected and you're going to put on whatever attachment, either attachment 1 or attachment 2, what item you're correcting, meaning what bank account. Say I said Bank of America 1234 had $3 in it, when in actuality Bank of America 1234 had $23. I will mark this corrected. Then you have reappraisal for sale. This is only used in like a conservatorship or a probate where you're seeking court approval for the sale of real property and your inventory and appraisal has not been done within 1 year. So it would be, if you look at the date on this one, the inventory and appraisal might have been done in 2025, but it was valued as of this date. So you would need a reappraisal if you're going to sell property now. And keep in mind, every single conservatorship guaranteed, if you're going to or need to sell real property, it must be through court approval. Property tax certificate, I don't, in fact, in my many, many, many years, I've never used this one, so I'm not fully familiar, but I'm sure it has to do with property tax transferring of title, things of that nature. So we're going to skip this one. Alongside here, you will have your case number. Make sure you glance at the case number and the case number matches the name on the case. And more importantly, this date down here, which is a very important date, and I see it wrong many times, like close to 9 times out of 10. But once people understand what this date is, they do, get it right. So this date right here is the date that you went to court and the judge ordered you conservator, administrator, executor, guardian, what have you. That is what this date is. This is not the date of letters. This is not any other date but the date that the judge ordered you. Now, keep in mind, sometimes with conservatorships, you will have a limited conservatorship first, and then you will transition into the permanent conservatorship. Make sure this date right here is the date of, if you were issued temporary, it's that date. If you never sought out to become temporary, and typically temporary means you have an immediate need. For instance, you found out you need to get your mother, sister, whatever, into a care facility, and the care facility wants to know that you have authorization because there's no other legal papers to do it. You have authorization to put them in that care facility. You might petition the court and say, hey, I need this immediately so I can get them into the home while the court takes the process to give me permanent. So this date is very important. It carries on to the accounting, and everything regarding the accounting will revolve around this date if this is your first accounting. Any questions up to this point? We're halfway through the form. I'm tongue-tied this morning. Okay, moving on. As you will see in line 1 says attachment 1, and we are going to go through what items will go.
Excuse me, I did have a question,
Yes.
but I typed it in. Can I ask it real quick?
Yes, hon, go for it.
Thank you. Can this form be used in an effort to collect a debt from the trustee?
No, ma'am, it cannot.
Is this form required for the trustee to put the client, or the situation is that the one of the main trustees passed away, the other one has dementia, and then
Okay.
there's someone, another trustee after that, a brother-in-law.
Okay.
That brother, and in the trust, it says that she wants to stay in the home and live the rest of her life.
Yeah, this has nothing to do with that, honey. This
Is
is
this, you mentioned, I'm sorry to interrupt, just so I don't waste your time real quick. Um, is this form necessary to put that person in the nursing home?
no, the
Thank
appointment
you.
of a conservatorship is what would give authority to do this.
Got
This
it.
only happens after you've been appointed and you know you must do an accounting for the
I
court.
see. And in the other case, the trust appoints him already, so I see the
Correct.
difference. Thank you.
So, any more questions? Sorry, I didn't mean to interrupt. Okay, so you have two attachments typically that are attached to this inventory and appraisal. Attachment one, keep in mind, and it's actually fairly simple. Cash. That's all it is, cash. Anything that's cash is attachment one. But keep in mind, cash can be checking, savings. It can be an uncashed check. We'll go through those different items. But typically, attachment one is cash and it's valued by you. Attachment two is anything that's non cash and it's valued by a probate referee, which you would have been assigned a probate referee on your initial papers. And if you weren't, then you need to complete another form for the court requesting a probate referee. So we're going to go through the different attachments, and I'm going to slide down my screen and move it to a different screen, which I opened my PDF in the wrong PDF, so I can't use the pages. Anyway, so this is attachment one. This will be a blank piece of blank, but of course the forms without all the detail. I mean, the form will be not completely blank. You'll have your headers, but you'll need to complete it. It is the DE 161, which follows right after the DE 160, or it's considered the GC041, which follows the GC040. So you will need to mark it attachment one, and you will need to complete what cash items that you have as part of the estate. We're going to or part of the conservatorship, part of the trust, or part of the minors. Typically, you will not see all of this for guardianship or minors. You might see one. It might be either cash or it's real property typically. So this is a whole lot of examples, but this is very common for conservatorships. Okay, so cash found at the residence or cash found in the conservatee's wallet. I will tell you, when you are handling older people kind of right now, they are very cash conscious. They don't know apps and they don't know ATM cards was just blew their mind long ago. So you can imagine what Apple Pay and all this other stuff does to an older person right now. They have no clue what it is or how to use it. They have always used cash. So a lot of times you will find cash in their wallet at their house, stuffed in their underwear drawer in an envelope. It can be so many different places that you'll find cash for older people. If you do, it is very important you record it. So cash found at the residence, or typically I would just write cash found um, in conservatee with conservatee or cash found in residence. And you must indicate the amount. Also, and Rex, FYI, you still have your mic on so I can hear your conversation. I'm not sure if he can hear me. Anyway, balance in the checking account. Please remember, do not ever put the entire checking account number on this. It should either be, I typically use the last four digits of the account number, but remember, public information. If you have a conservatorship that has a continued bank account and you put the entire account number, I will guarantee the court's going to come back to you and say you've now jeopardized that conservatorship's bank account, because this is public information that anybody can see what their entire checking account is, and they know they're under a conservatorship. So that's extremely dangerous. Please, please, please don't ever put the full account number. I don't necessarily put the bank name where, like mine might say Wells Fargo checking account 4655. That's all. I don't know where the branch is and the address, and there's Wells Fargo's all over the place, or Bank of America. So all of that is not necessary. But what's really important is that you figure out the balance. So remember, this is the balance that you're trying to get to. I'm going to slide back, so I don't want to make you dizzy, but I'm going to go back. You need the balance on this date. Keep in mind, you may look at a bank statement and it might run, let's say, January 1st to January 31st. Well, I'm sorry, March. Let's go March. March 1st and end March 30th. Well, you need to figure out the balance on this specific date. What you may have to do nowadays, the bank statements will show daily or almost each transaction, they'll show the balance, so it'll be easier for you to figure out. But long ago, and with some bank accounts, you still have to go, okay, what was the balance on March 1st that's showing on the bank statement? And then let me add in all deposits up until the 8th and subtract out all the expenses before the 8th to come out with my balance on the 8th. Now, keep in mind, the first thing I'm doing, one of the very first thing I'm doing when I'm starting is in accounting, is I'm looking at the state, I'm going directly to the bank statement, I'm looking for this balance. If that is not the balance, I will tell whomever gave me the project, I cannot proceed. If it's a law firm, I can tell them why I can't proceed, and I explain to them their inventory and appraisal is off. But for pro pers, basically my response would be, looking at this line item, I do not see that this bank account had this balance on this day, and until it's corrected, I can't proceed. So very important. Courts will get it. Courts get bank statements, so they will look at it also. Very important. This is the number one reason these get corrected, is because the balance listed here is not on that 8th day, or not on the proper date. So make sure you look at that, get your numbers correct on this balance right here. Okay, moving on. Savings account, exact same thing. Doesn't matter, you have to list it separately. I typically would put Bank of America savings account 4654 and then balance. Same idea, balance has to be on that March 8th date. We have a CD account. Typically, it's on the same statement as maybe the checking or the savings, or sometimes all three are on one bank statement. They must be listed separately. So I'll list CD. I typically don't know all this information, so I don't include it. I only include CD number and put the CD. Typically, CDs won't be listed like this. I've had times where I've completed a inventory and appraisal, and believe it or not, I had 350 different, those were bonds, not CDs, but bonds. And I had to list them separately on attachment two, not on one, but it took forever. So you could have more than one CD account. Make sure you list what the balance is on the date of that March 8th, which is the date you were appointed. In this is sample when they used to mail checks to people. This is not done anymore, typically direct deposit now. In fact, I really don't see this at all. But in this case, when the conservator went to the conservative's house, they opened mail and found there was uncashed checks. This happened to be from the pension. You would indicate the check amount. Now, again, this is sample only. If you do not have these things, you won't list them. Like you may only have one checking account and that's it on this entire page. That's fine. That's all you have. Another sample would be Social Security check that wasn't cashed and the amount. Maybe a dividend check. Most of the times I don't see dividends come in a check monthly, but for some older people, they have to because of tax laws and how they have to take the minimum distribution on, or things like that. But typically they are dividend reinvested, so you're not going to actually get a check. So you will take all of your totals, and on the bottom of the page, you're going to say total attachment one. You will take this total right here, and you're going to transfer that back. I'm going to slide screen to this page right here, because you are allowed to value all attachment one assets. Now switching to attachment two, I'm going to slide my screen again. Attachment two is completed for the probate referee. Again, you will have to put attachment two on here. And what are you going to put on for the probate referee to value? Any non-cash asset. And so we're going to go through examples. One is they owned a house. This is their real property. I try to give as much description to the probate referee that I can. First, I start off with, do they own it 50%, 100%, 25%, 33 and a third percent? Like percentage of ownership can vary depending on how many other people are on the deed or own. Maybe they own 100%. I list the city, county, state. This is the legal description. You may not know that legal description, and that's perfectly fine. If you don't know that legal description, a lot of times I'll add, sometimes I won't. If it's a big lot, typically I'll add the legal description, or if there's specific things about a condo, sometimes they give rights to a parking spot, things like that. So I list the property address, commonly known as, and the APN number. Typically, you can get the APN number by county assessor's office, typing it in. If you don't have the APN number, it's fine. The probate referee will figure it out. And you will notice no value is given. That is because you are not allowed to value this property. And keep in mind, this probate referee will value the property, even though it's October 16th today of 2025. They are valuing the property with this date. So they will provide the value on this date. Do not be alarmed. Because of the fact sometimes people get these back and they think they have a house that's now, let's say, worth $1 million. Okay. House worth $1 million. Well, guess what? They get this back from the probate referee, and the probate referee values it at 300,000, and it's a sticker shock. You go, "Oh my Lord Jesus, what happened? It's worth $1 million." Blah blah blah, right? Don't panic. The value is of 2012, and likely the value of the property in 2012 was only 300,000, and now it is worth $1 million. Again, this value is only as of this date, which is the appointment date of the conservatee or the date of death of this decedent. And so don't panic that the values on your inventory and appraisal are not what you think they should be. Okay. So now we're going to go down to the second example, which is vacation home. So this person had a vacation home, same concept. You would want to list if they own it 100%, 25%, 50%, so on and so forth, and use the same thoughts. Household furniture and furnishings, typically this has a very low value. Keep in mind, and this is important because some people get a little bit upset, a probate referee will only value household furniture and furnishings pretty low. I've seen them $500, $1,000, and people go, "My gosh, the whole house is filled with furniture. What do you mean?" It's resale value is what they're determining. Keep in mind, if you have some type of, let's say, antique furniture, maybe you have a baby grand piano in perfect condition or something of that nature, do not group it in your household furniture and furnishings, right? Split it out as a separate line item so the probate referee can only value that one piece. Again, furniture and furnishings do not include paintings that might have value or anything of that nature. If those paintings have value or you believe them to have some type of value, you must list them out separately. Do not group them within this because this really is only talking about sofas, recliners, beds, dressers, things, maybe dining tables, chairs. Typically, those are very low value items for resale when somebody has owned them for 50 years or 30 years and they haven't changed them out. Okay. Now we're getting down to shares in a mutual fund. It cannot be listed this way. You have typically unless this is your only investment fund item on this statement. So you need to gather whether it's Charles Schwab or any of the other ones, Morgan Stanley's. You need to grab a statement and list every share or every mutual fund or every equity account. Even sometimes these investment accounts have a cash account and they have an investment account. Make sure if you see that the cash account goes on your attachment 1 and your mutual funds, stocks, things like that go on attachment 2. So they will be split. Savings bonds. This is where I was using the example $700 US savings bonds. You are not allowed to list them like that. You cannot lump them because each savings bond, depending on the date it was issued or its series, has a different value. So you would have 7 line items for each $100. And the series will be a different series number specifically for bonds. And this is where a case where I am not kidding you. It was like 150, 200 savings bonds. I must have had, I think, 10 pages of attachment two, line item, like literally line item one in a row. I was almost cross-eyed trying to make sure I got each line item and proper serial number. And I know the probate referee cursed me out upside and downside when he got that, or she, because I know it was a lot of work because it took me a lot of work. So the value and looking up that value for them probably took them forever. But
I had a question. What about managed funds like a pension? Would that be listed or no?
pensions, no, hun, because pensions really aren't something that, say, for instance, there's a death or something, you
Yeah.
will get that pension after the fact. So it's not, pensions are typically not inheritable items.
Yeah.
Yes, I realize some do, some carry on to the spouse or after death. But no, pensions are not listed on here unless it's a pension check that you got and just wasn't deposited yet.
Perfect.
Does
Thank you.
that make sense, son?
Yeah,
Okay.
absolutely.
I have a question.
Yes, son. I'm sorry, I
Can you
don't.
hear me now? Can you
Yes,
hear me?
I can.
Okay, great. I didn't realize I had just muted myself. Quick question, Tamara. Let's see. There's a probate referee, and then there's this position. Who does what, and how is that determined, and where can I read to determine that? Because you're talking about don't value this, don't add that. What I'm trying to get the line of distinction between what the probate referee has done and what our task is.
Okay, so let me back up before everyone and answer the question. So basically, most people, unless you haven't completed this process yet, but petition the court to get appointed either conservator, guardian, or administrator, executor, things like that. So appointed by the court. So your appointment means you manage, and the only time you would do an accounting is if you were, say, conservator of the estate. A lot of times somebody can get conservator of the person. This will not pertain to you whatsoever if you're only conservator of the person. You could be conservator of the estate, meaning you handle money, then you must do this. Or you could be conservator of the person and the estate, then you handle this. The difference being is you do everything. The only task a probate referee has is to value non-cash assets for the court. All this really does is tell the court what is the value of this conservatorship, because keep in mind, the court is monitoring and making sure that just because this conservatee may have dementia or some other physical ailments, that they cannot handle this themselves, and it might be nothing at all. Back in the days, you had husband and wife. Husband took care of the checking account and all the bills. Wife never touched or even knew what a checking account was. And now husband passes away. Wife has no clue where to begin or how to pay bills or manage money. So they may only have that as what's considered their ailment. They don't understand how to pay their own bills, but that doesn't mean medically something's wrong with them at all, not at all. So again, you are managing these funds. The court is making sure you're managing the funds properly. The only way they know that is they have an independent person that tells them the value, say, for instance, of this home right here. So, say, for instance, and I'm saying for instance, and y'all are going to laugh, but it happens all the time. Say, for instance, this house disappears, meaning a nephew, a cousin, somebody talks the conservatee into signing over deed paperwork to them or to sell this house because uh maybe I should use the vacation home. You don't need this house. I know I can get great money for it for you. So they put the house on the market, they sell it, and they haven't fully told their grandma or whatever that they're keeping the money. And so this house is vacation home is no longer theirs. Guess what's going to happen? The court is coming back to you and saying you will replace the value of this property. And they know the value because the value was given by the probate referee. So just understand anything that is non-cash has to be valued by the probate referee, but you are still ultimately responsible for cash and non-cash assets. Does that help?
Yes, it does. I just wanted to make sure of, who's on first and what's on second. Thank you.
Gotcha, honey.
I need to go back. I really do. I got two quick questions. How often do I have to do this once I'm, if I'm assigned, which I assume I will be? And the second one is I'm confused about, he only has one bank account.
Okay.
So when I write down, so first let's go to the first one. How often is this done?
One time.
Just one
At
time.
the beginning, one time. Do within 90 days of your appointment. One time and one time only.
And so on that date that I was given or,
Appointed.
then I just put whatever's in his checking account at that time.
Correct.
And now I am a rep payee on there, but it has his name on it. So that is his account. That's the one I use.
That's the one you use. Yes.
Right? Okay.
Yes, ma'am.
Thank you.
You're welcome. Okay, so I'm gonna go on for other examples because I have about 7 minutes and we're getting close and I got the rest of the form. So other things, diamond ring, 2 carats, please make sure you list everything. Remember, what you're you're not only doing this for the court, right? You're doing it for the court, you're doing it for beneficiaries, you're doing it for this person's family if they have any, you're doing it for a lot of people look at this. Now, a lot of people have asked me, why is this important? What size a ring is? And if you want to know the truth, myself, I'm in trouble because if I have to look at somebody's wedding ring and determine if it's 1 carat, 2 carat, 4 carat, 5, yes, I think I would know a 5 carat, it'd look rather big to me. But I know nothing. I'm not a diamond-y person, so I wouldn't have a clue. Please do your best at this. A lot of times, say for instance, you complete this, the beneficiaries receive a copy, they come back and go, wait a minute, where are her other 2 diamond wedding rings? That's your cue to, oh my goodness, I don't know, I haven't seen them, maybe I should go look, try to look for them, things of that nature. This is just very helpful so that later on or during your process, a beneficiary doesn't try to convince the court that you've absconded with this wedding rings or you've done something fishy. And believe it or not, all kinds of accusations can come. So please be sure, list everything like that. If they don't have a wedding ring, of course, you wouldn't put it here. You may not know the size. You may just say diamond wedding ring looks like a princess cut or a round cut, or, and you may not even know cuts. I'm not great at that either. But I'm going to do my best to describe everything I find. There could be many more things. Art collection, you would list vehicles on here, but remember, when you list vehicles, you need to state year, make, model, mileage, is it running, is it non-running, maybe it hasn't been registered in 10 years, maybe no tires on it, engines missing. Even if that's the case, list the vehicle here, list everything. So no one says, oh, they, now I wouldn't, let me back this up when I say that. I've had, and somebody called me yesterday, has two huge garages full of tools. Do I need to list the tools? Oh my God, no. There's no way you could possibly do that, right? Maybe state an entire garage full of tools, but not individually what they are. But maybe there's a riding lawnmower, or some type of big equipment in there that you would want to state. Just state what you know, what you see, what you have, and if somebody contests it or a beneficiary says, hey, you left out this other car, well, that's your cue to go looking for it or trying to figure out where it is, and then tell them, I'm sorry, I didn't see it, and then maybe you'll have to do a supplement later. So let's continue on. Those are all of our examples. Again, no values here. I haven't listed a value here. Once this is completed, you'll go back to your inventory and appraisal. You'll note I did not list a value here. That is because you're going to mail this off to the probate referee with all the schedules, and they will put a value here and they will total it. Now, let's complete real quickly the rest of the form. I'm going to go down. Number 3 says attachments 1 and 2 are either all of the assets, and that's why I marked final, or they're a portion of the assets, and that's why I'm only marking partial, supplement, or corrected. Number 4, no probate referee is needed. Say this person only has a checking account, nothing else, no car, no real property, nothing but a checking account. Very common for guardianships. Then you will mark this box, no probate referee is required, because again, you do not have any attachment to assets. Or it is, and by order of the court, you will get an order the day you were appointed, either a temporary or permanent. When you were appointed, that is the order date. You will indicate here the day of that order.
I had a quick question.
Yes, son.
Is there such a thing as a de minimis kind of amount? Like if all my mom has are a couple of chairs and a couch and they're not real valuable or expensive and they've been used, and maybe a couple of desks, do I have to declare that and get that appraised?
No, not something of that nature, unless, and I say with a big unless, say it's a probate and you have contentious brothers, sisters, everybody's fighting, everybody wants a chair or a rug or a blanket or stuff like that, and you think that they're going to give you trouble and you just want to do it, then yes, do that attachment to and say, a set of dining room chairs, used, worn, whatever, and maybe do it. But remember, when attachment to and sending it to a probate referee is going to cost you. It's typically 0.01% of everything they value is how much they charge you. So you may not include it for that purpose. Like for you yourself, the one who asked the question, I wouldn't include it even if people were contentious. But remember, if you're getting rid of that property, please, I always say this, prepare a list or maybe pictures and send it to all beneficiaries and say, I'm cleaning out this residence because we're going to put it up for sale. If there are any items here that you wish to have, before it's sent to the dump or maybe Goodwill, or we try and put it up for a liquidation sale. Do you want any of these items? And that usually helps people not fight over something or get mad if you've gotten rid of something that they wanted. And believe it or not, I had a case recently where there was something about an apron, and somebody wanted this specific apron, and the person in charge threw it away because they just thought it was a kind of worn apron, and it was a whole big huge mess. So that's my only suggestion, hon.
Okay, thanks. For
So
conservative.
I'm sorry, what, hun?
I said, thanks. It's for a conservative, but I assume the same thing. It's not very valuable. It's de minimis. It's okay.
Correct.
Can I ask just one quick question? When my mom passes, it's my understanding that my son will inherit money in a trust, but I won't be the conservator, and I don't think it's going to become available until after I pass, because it's kind of for his future. Do I have to submit all that information?
No, that will be no, because you're saying she's not passed yet, so you wouldn't say all that until
I
she
know,
does.
but when she does, my mom isn't in great health and she's 87. I mean, we hope she's around for years, but once she passes, and I know that there's actually money in a special needs trust for him, and I'm not the conservator, do I then, man, I'm gonna get a hold of an attorney, but do I need to report that?
Yeah, your suggestion is best.
Okay, get an attorney.
Contact an attorney and have him tell you that, hun.
Rex, I'll be talking to you.
Okay, so now we're down to number 5, the property tax statement. Realize it says property tax. If there's no real property, you are not gonna, you're gonna mark A, not applicable. If there is real property, all this is saying is that you have notified the county assessor, if there's real property, that you have now taken over, or that you are now the conservator and you will be responsible for paying property taxes. Very simple form to complete. But again, you're either marking A, you have no real property, or B, that you have notified the assessor that, and you filed the change of ownership, stating you are now going to be the responsible party for paying the property tax.
Do I have anything else?
Remember, it's very important to not sign this before it goes to the probate referee. You actually can put your name here, but do not date or sign it until it comes back, because you are declaring under penalty of perjury that this information is correct. If you're signing that statement before you even know what the probate referee does or what the probate referee values, you could, I mean, this is a legal document. Do not sign it until you see it's complete and you know what you're signing and it's all here. And you're saying I'm responsible for all of this now, not just responsible for this 57. So when you get it back from the probate referee, you will date and sign it and turn it into the court. But
Question, so if we don't need a probate because he doesn't have any real property,
you'll
then
date
go ahead and sign it?
You'll date and sign it now, honey, and turn it into the court just as it is.
Okay.
So, statement about the bond moving down, was the bond waived or not? Some cases bonds waived. Or did the court force you to get a bond? You'll mark this box and put the amount on the bond. Now, one quick question in these two statements. Say, for instance, the court only ordered you to a $20,000 bond, and as you will look, you indicate, mark this box and say $20,000. Yet you see your cash alone is 57. If your cash is 57 and your bond is $20,000, are you marking the box sufficient or insufficient?
Insufficient.
Go ahead, sorry.
I assume that would be insufficient. And does everybody have to get a bond?
No, only if the court orders it before you were appointed.
Okay.
You are correct. Insufficient. That doesn't make you wrong. It doesn't mean the court's coming after you, knocking on your door tomorrow, sending over agents. No, nothing like that. It just means you're being honest that you realize your bond is only 20,000. It doesn't cover the full amount of the cash. And so you're indicating that to the court. When the court reviews this stuff, which typically would be when you turn in an accounting, they are going to see this, or their examiner will note the bond is insufficient, and they will have you increase it possibly up into the value, or they'll ask for some of this to be put in a blocked account or something of that nature. But they will handle it, so don't worry about it. You're just going to be honest. Is it sufficient or insufficient? Coming down one more, receipts. If you've been ordered, this is very common for guardianships, to put money in a blocked account, or if all of the money is in a blocked account, you would just indicate this box and say how much is the balance in the blocked account. Then you got one more, date and name. Again, this would be where the lawyer signs if the law firm was completing this, but you yourself would just repeat your name, both lines. Do not sign it till it comes back from the probate referee. The probate referee will complete this page right here. They will put what their commission is or how much they're charging. They will put if there are any expenses like toll, mileage, maybe they had to go get copies of maps, whatever their charges are, they'll indicate it here. And then they'll put the total amount that is owed for valuing the property. They'll send you also a separate invoice, but this goes to the court so the court can see how much they're charging also and make sure they're not charging more than the amount they're allowed to charge. They will date it, they will print their name, and they will sign it, and they will return this and all attachments back to you. And again, once you get it, you will sign and date it, and you will turn this into the court to be filed. And again, when I'm preparing an accounting or asked to prepare an accounting, the first thing I'm asking for, inventory and appraisal. Then I'm asking for bank statements. I'm matching them. So it's very important that your inventory and appraisal is correct. And if you yourself are doing your own accounting, you need this inventory and appraisal to be correct. Otherwise, you'll never be able to balance in the end. Are there any more questions about the inventory and appraisal before I send you back with Rex, who will go through the accounting?
If everything is Schedule 1, meaning just cash, is it necessary to get the appraisal?
One more time on your question, honey. I'm sorry.
If everything is cash, i.e. Schedule 1, is it necessary to get an appraisal? You know, if it's just checking accounts and maybe CDs.
Okay, you must turn in an inventory and appraisal, whether it has been valued by a probate referee or not has no bearing. Even like you will not be in a conservatorship if there are absolutely no cash and no property, because really that's unheard of.
Right, but the question was, if it's just cash, do I need to get it appraised? Do I need to go to the probate referee at all?
No.
Okay.
So you will, if there's no cash, you would indicate the word zero. I'm sorry, no non-cash. You will indicate the word 0 right here, and typically on the attachment 2, I will still complete it, and I will write 0 right here, and I will turn it in. And therefore, when an examiner, the court, whomever is reviewing this, they're not thinking that you forgot to go have the probate referee value. They know you've indicated there are no other assets to get valued. Does
Whoa,
that make sense?
to back that up just 1 second. So if it's only a checking account, he has $40 in it. I don't put anything under the appraisals on page 1 of DE 160.
You put only the balance in the checking account, $40 right here, and you'll
Okay,
put 40 here. On your attachment 2, you will still complete it, but you will say there are 0 non-cash assets. And when you go back to your front page, this will say $40. This will
okay.
say 0, and this will say $40, and you'll sign it and turn it in.
Say that again. Can you slow down just a tiny bit? I'm very slow. So where does the $40 go? On
Okay,
line 1? No, wait
the
a minute.
$40 goes first on attachment 1. You will
Okay,
list bank account balance $40.
got that.
Where it says total down here, you're going to carry this number down to here. This will
Okay,
say $40.
okay.
Then
Uh,
you're going to take that $40 to here,
uh-huh,
front page,
uh-huh.
and you're going to write $40, right? So
Okay,
now you've covered what your assets are.
all right.
Under this line item, I'm going to write the words 0 or
Okay,
put a 0. And I'm just going to state my balance down here is
okay,
only the $40.
okay. All right.
When I get to attachment 2, because I want the court to know I just didn't forget it, I didn't have anything, I will complete an attachment 2 item. I will write 0 here and turn it in with the all of the forms.
Okay, got that. Thank you. So if his bed is just an old bed, but it's, do I need to write all that down? Like,
No,
okay.
no,
Then one other thing, do I have to attach his bank statement?
no,
Okay, great.
never.
I'm good. Thank you so
Remember,
much.
you'll see later on how bank statements are submitted to the court. Yes, ultimately you will submit bank statements, but they will never be attached to any document that's public. You will complete a completely separate confidential cover sheet for bank statements that alerts the court, do not put this on the client portal, or do not put this anywhere that anybody could walk in and gather this information. It's considered sealed, kind of
Okay.
like an adoption. If you do an adoption, the original birth certificate, you can ask for it to be sealed, meaning no one can have access to it except for the court.
Okay.
The bank statements become sealed, meaning no one can look at that information except for the court.
So are you going to be covering when we need to turn these bank
Yes,
statements in?
that's at the
Thank you.
last part with the
Okay.
petition.
Okay. Thank you.
Okay, moving on to Rex. Rex, are you here? And he just
I did have a quick question.
go ahead.
Yeah, in terms of the probate referee's fee of 0.01%
Yeah.
for so let's say there is property, California property, say it's $1 million house. Does that mean that the probate referee can charge $10,000?
It's one, yeah, it is their fees, hun. That would
Wow.
be, it is their fees.
Okay.
I think there's some type of cap once it gets to a higher number. I don't control their referee fees. I don't know. There's a whole probate referee handbook that talks about what their fees are and how they can charge their fees and so on and so forth. So I don't know if once it gets to a specific dollar amount, they're capped, meaning they can't ask for any more. I just would not know that answer, honey.
Okay, thank you.
Honey, where's the tea bag?
Okay, I wasn't sure.
I said tea.
And Rex, just as an FYI, I tried telling you a couple of times, you did not mute. So the entire time you were talking to your staff, we could hear everything you were saying, if you were near the mic. But I'm going to pass this over to you. I'm going to figure out how to. I lost my
Can
Zoom
we take a
connection.
1 second break so I can use the facility?
Go ahead, go for it, hun. Okay, now I'm back here.
So I believe, Tamara, if you go to your picture, there may be a thing about changing host.
Yeah, it's a little bit different, but sure.
Quick question for the new speaker. What section of the book of what we've been sent are you going to talk on?
I am going to talk on the summary accounts, starting on page 21 on the lower left.
Okay.
Summary of it. Don't worry about it. I'll connect you when I start talking. I'm not going to leave you in the dust.
Well, I wanted to be prepared. So that's why, because I have
It's page,
vision issues, so it's easy. I'm just trying to be prepared.
okay, it's 21, page 21 on the document. In my stack, it's page 23 of the PDFs. And it says summary of account, and the big words charges and credits.
So it's in the same booklet, and I'm looking.
Yes.
So I'm looking for page 23 at the bottom left.
Okay, there's two sets of numbers. That's what I'm going to cover all this, but lower left is page 21 in big numbers. That's what it is. In the PDF, I can't control the PDF page numbers. That's page 23.
Rex, I've shared the screen. It's yours now.
Okay, you've turned me over as host?
Yes.
Okay, so I don't see that happening yet, and I don't have Zoom controls anymore. I'm not the host, Tamara. You need to transfer host to me, so because I can't share my screen. Does everybody see a form that says charges and credits on it?
No, we see your face.
Okay, you need to transfer.
And on
Yes.
my side, it says you are host under your name.
Yeah, maybe what about the icon at the bottom that just says share screen? If you click that.
That would be you, Rex.
Bottom of the screen says what?
If you go down to the lower, it says share. It should be in the middle icon.
Okay. Okay. Is it sharing now?
Yep,
You see a form that says charges and credits?
correct.
Yes.
Where would that be? At the top?
No, right in the middle of the page.
That's
Which
showing.
page?
I see it.
You do see it, Tamara?
Yeah.
Okay, that's
Does
great.
everybody else
That
see a
doesn't help me.
form?
Yes, I see it.
Thank you.
Mhm.
I see a form, but I'm not looking at this particular. I'm looking because my Zoom is on my cell phone. It's too small for me to see. So I
Okay,
have
somebody
the,
that's looking on a computer, I'm just trying to get verification that our signal went through, and it appears that it has. If you don't see the summary of account form, then let us know and we'll make adjustments on that.
well, just like you said, if there's somebody on their computer, they're looking at the PDF. I need to know the PDF number on the lower left side.
Okay. I will continue now. So in my section, I'm going to be covering the forms. And the way that the forms are set up in the packet is the lower left of each form has 4 digits and a number. Our page numbering is 21. And if you have a PDF screen, If you're looking at our screen, no problem. If you have our handout open in another PDF window on your computer, the page number might be 23. Does anyone not see charges and credits and summary of account?
I don't yet.
Are you on the phone?
I'm trying to get to your page 23. Hold on.
Are you on a computer or a telephone, ma'am?
I'm on both. That's what I was saying. So I'm looking for 23. So I just found 23 in the lower left-hand corner.
Okay, if you're
And
looking at the
so
lower
the top
left,
of it,
go back up to page 21 using the lower left numbers.
okay. What's the title of the page I'm looking for, please?
Summary of account. It's
Because I'm seeing something that says Schedule A. Schedule
okay, I'm
A
gonna
and
let you continue to look, but I've given you the reference of page 00021 in the lower left. And if you're looking on a PDF, then it would be on a page 23. So I need to continue here. So
is it
once
1B? Because there's two 21s. It says 1B.
it's only page 21.
Okay.
Okay, so continuing on, we're going to cover the summary of accounts. This is the pivotal form in all fiduciary accountings. Everything revolves around this form. This is a judicial counsel form that is required. In the lower left, you'll see Judicial Council of California. Judicial Council is like the board of directors for the courts. They're directly under the California Supreme Court. And the next office below that is the administrative office of the court. So the courts have agreed this is a required form for all probates, all guardianships, all conservatorships, and the probate code provides that it is to be used for reporting for trusts. If a trust has to be reviewed before the court, then the trust has to use this form also. We're going to cover a lot of different forms on different kind of expenses and income categories, and all of those are optional. This one is not. The
Is
way
this
that
trust
you
only?
say again, please.
Is this for a trust only?
No, if you look on the bottom of the page,
Yeah.
you'll
I
see
see it.
that it's for probate, guardians, conservators, and trusts,
Okay.
anything to do with court accounting.
Okay.
So what we're going to be talking about in the heading, it says summary of account for standard and simplified accounts. The simplified accounts we're not going to be talking about. That's it's an idea. See, there's a conservatorship and there's one check every quarter, so there's 4 checks for the year. Very few transactions. That ends up looking just like a check register, and the courts will accept it, but we're not teaching that. It's not utilized very often. We're doing a standard account. So on this, all these forms are available online when you do a search for court forms. Here you set up your case number, the name, and there's no place for trust. If you're doing an account for a trust, you just make your own box and fill it in. Here, trust accounts are given by years or how many times you've submitted your accounts for court approval. Generally, you file your initial inventory and appraisal 90 days after you're appointed, if that hasn't changed. And then that's just the inventory and appraisal. At the end of the year, you do your first complete account, all income and expenses. And then after the first year, for long-term accounting, you do the accounting every other year. So you're looking at doing accountings in the end of year 1, 3, 5, 7, and 9 that you turn into the court for approval. So we have the first, calling the first account, and the date range is from March 8th beginning to March 7th the next year. And now the sections of the forms, first of all, the definitions. The top is for assets and income. The bottom part, credits, is for money going out and ending assets. So the terminology charges, I don't really like the word charges because it sounds like something I put on my credit card and then I owe some money. But that's not what they mean by charges. What it translates out to is that you are charged with the responsibility of this money. And if the money disappears or is not accounted for, you are personally liable. And the court will enforce that. So you can look at the word charge as kind of burden. What's your burden that you have potential liability for? So Tamara just went through the inventory and appraisal in detail. Now, in the accounts, you have to tell the court again, what was the property on hand at the beginning of the period? So you get your inventory and appraisal and put the cash and the assets, the non-cash assets, and then get a total of property on hand at the beginning of the period.
Would that be for the whole year? Like, so every month he gets SSI, or so would that be that total for the whole year then? And
No,
not the first year, right?
no, let me clarify.
Okay.
This is at one date. One
Okay.
date. On one day in the beginning of your account, let's say when you were appointed, you got your letters, what assets did you grab onto that you're in charge of?
Okay.
It's not income. What
Oh.
stuff did you get that we're going to hold you accountable for? And at that point, I had so many cash accounts, I had real property, probate referee. This is a copy job from your inventory and appraisal form that Tamara went over. You just bring
Okay,
the
so
totals.
if there's nothing other than the $40 in his checking account on that day, then this doesn't apply to me?
No, it does apply to you.
Oh,
It says cash assets.
that's what I would.
$40 is a cash asset.
Okay, thank you.
And if there's no non-cash assets, put a 0.
Okay.
And then $40 on line 1C, that's all I have.
Okay, thank you.
The other thing with, I'll point out, since you said the small dollar amount, probate code section 2628 provides that you can petition the court if you have less than 15,000 of assets and petition the court for a waiver of accounting.
Oh.
You still turn in the bank statements, but there is a provision to help smaller estates and conservatorships not go through all the administrative requirements.
Oh, great. You said that's probate 2628?
Yes.
Thank you.
Okay, so we're going to figure out how this form works. It's pretty simple once you get used to it. What do we have in the beginning? Now, starting on line 2, we start getting into what came in whatever format. What additional funds were received. So we have a generic additional property received during the period. Say the conservatee inherited real property, you would add that came in during the period. Then we have receipts during the period, Schedule A, and what kind of money came in, no matter what type. And you look at these Schedule A's, and it's not just a Schedule A. You look at it like it's a link that has other schedules underneath it. So we'll get into interest, we'll get into dividends, we'll get into capital gains, other types of income by Schedule A and then a sub-page number. Any gains on sale of property will cover Schedule B. Other charges. I don't like the word charges, but that's what it is. Say you've got miscellaneous, got a refund on a tax return or something like that. And you have to account for every penny because you're like a bank, you're handling someone else's money. So in income tax, we round off pennies all the time. IRS doesn't want them. But in court, they're a little bit more anal retentive and they want every penny accounted for, which makes it kind of a problem when you're trying to balance. When your ward or the trust owns a business, that could be a nightmare in terms of accounting. Fortunately, on line 6, you can take the accounting from the CPA who's doing the books for the accounting and just enter in the net income. Good enough, which is nice. So this is kind of a brief overview of the total of the beginning assets plus all the money that came in. Now we're going to flip and go into the negatives where the money went back out. So here, disbursements under Schedule C, and we'll have a lot of subschedules like administrative expenses, house payments, rental, all those ones we'll cover in the class here. Losses on sales, that might be stock sales. It might be taking an asset like a car and selling it for the ward.
Even James.
Yeah, dividends are considered income, so dividends would be up on Schedule A. Losses, we said, then distributions. So if you're giving the ward spending money, that would be a distribution. It's not accounted for. Further, other credits, miscellaneous disbursement type, and then the same on the business schedule. So we'll cover each of those subschedules in detail. And then at the end of the accounting, we have to go through the process similar to the inventory and appraisal, where at the end of the accounting period, it says up here, March 7th of that year, we want to know the reconciled balance of all the cash accounts and the carry value of all the assets that are fixed assets. I wanted to find the term carry value on line 1B and line 13B. What carry value is when you're doing a court accounting, like on a real property, once you get control of that asset, that's the value that's going to be on your books forever. That's called carry value. It's different. Most accountants are trained about basis, and basis is a tax term that we don't use here. And so when we had the probate referee value the real property, for example, that value stays on your books forever. It doesn't change. And it's different than tax with basis. So I just point that out if you have any kind of accounting background. The other part of this form in the lower right, and this applies to all judicial council court forms, it gives you probate code sections. If you want to know more about the law, where this form came from, maybe some of the subtle nuances, you can go to probate code sections 1060, 2620, and then the California Rules of Court 7.575. So, and you can get the forms in that web address on the bottom. So does anyone have questions on the overview of the GC 400 sum? Okay, good. All right, so we're going to move along. And the first form we're going to be working with is we're going to be going back and forth to this form. And so if you have printed out our handouts, you might want to put a yellow sticky note because we're going to be working on a form and coming back here. We're working on a form and coming back here. So in the beginning, it says cash assets, and the next page is non-cash. So we want the details. Cash on hand at the beginning of the account. There again, you go back to your inventory and appraisal and just list all the cash account balances on that date. Then you go to your inventory and appraisal and pull the list of assets that the probate referee valued for you. And I suggest, not everyone does it, but I suggest when you have your assets, you identify an asset number for each of your assets, whether they're bank accounts, give each one a separate line, number one bank account, number two bank account, number three, and the same with other non-cash assets. And the purpose of that is you have somebody reviewing your work when you turn it into the court called a probate examiner, and it helps them evaluate which asset number 17. Well, they can go to multiple years of accounting and find that asset number 17. And once you sell an asset, to keep that consistency, don't start your numbering system over again. Just leave asset line 17 blank in the future instead of trying to renumber everything, because you would not have multi-year consistency. So after you list your items for your cash and your non-cash, here again, we're in the inventory and appraisal form issue. Now you list them on line 1A of the GC 400 sum and 1B. So that's the first leg of your accounting. In our material here, we have a summary form, and I find it's useful. Some people like it, some don't. I like it because we're going to be dealing, you think of Schedule A. Well, I would think that's one form, but the way the court designed it, Schedule A is not one form. It's many. And when you have many different pages, this summary sheet helps before you bring it to your summary sheet. It gives you a middle accumulation section, but it is optional, and you're not supposed to file it with the court. So at this point, we're going to start going through what kind of income and where would you report it and how to report that income into categories and groups. Receipts, dividends. So you take the dividend statement and every dividend that came in, you have to list it. I would list it by, say, for example, you got two different mutual funds, have the name of the first mutual fund, all the dividends that came in during the period, and then the second name of it, mutual fund, and all the dividends, instead of sequential. You must use 6-digit dates. It's not optional. Include the pennies. And when you get to the bottom, page 1, your subtotal, because you're going to have other income. And we're on page 1 of 6, the page A schedules. And this is just the first category called dividends. And we don't bring forward to the GC 400 until we get through all of the income items for Schedule A. So the next schedule on your handout, page 24 in the lower left, is interest income. List each account, each distribution of interest, 6-digit date, describe the account. What we do is list the bank and the type of account, and generally instead of giving the court the full account number, because you want to protect the privacy of the conservatee or details to stop identity theft type things, we only use the last 4 digits of the account number instead of because this account is public record. Anyone can go to the court and get a look at the file or make copies. So you don't want to give out the confidential information. The next form is receipts from pensions. List each one that comes in. You don't lump them for one statement. And on this form, they would rather not have Social Security. So it'd just be company pensions.
I had a question, as in regards to the time capture that you're looking for. Is it leading up to when the conservatorship was granted or post, just for that, I guess, fiscal year?
Okay, so let me go back to the page 21.
Mhm.
This is our time frame. We call that the accounting period.
Yeah.
So the only things that are going to be shown here at all start on March 8th, and then everything that leads up to March 7th of the next year.
Gotcha.
Anything beyond that time range is not mentioned.
Mhm. Okay.
And so what that makes you do is take a bank statement and you don't use the whole bank statement.
Mhm.
You just go down however many lines to get to that date.
Okay. Thank you.
You're welcome. Okay, so we had interest income, we had pensions, rental properties. You would list the address of the property. I'd list whether it's a single family home or a 100-unit apartment building. And the rents that come in, if there are several, I would list them under each rental separately. Then here's a receipt of Social Security. The court employees, the probate examiners in our court, in Contra Costa Superior Court, are required to take our class when they become a probate examiner. We had an examiner in the class, and she spotted this immediately as being completely unacceptable. Here we have Social Security. So what somebody did was they took 3 months of payments and said, we got 3 months of payments. I'm putting it in as one number. No, you're not. The court will not take summaries. So you have to list each of the three separately, or it's going to be rejected. And these are automatic payments into the bank. And so you'll be pulling the information off the bank account. The other thing is, when we do a lot of income tax, in addition to postmortem trust and estate administration, and when you get a year-end statement for Social Security, you'll have a higher number, and then they'll have Medicare taken out. And in your court accounting, you're not going to show that the top number of what Social Security thinks that they paid. All you're responsible for as a fiduciary is the cash or the check that was put into the bank. The fact that they took out Medicare before you got it is none of your concern. You could not control it, so you do not have to account for it.
Does this include SSI?
Yes,
Okay,
it does. Social Security and SSI.
okay.
Then other income, we have receipts, other. Miscellaneous income, anything else that did not fit in another category. There are 37 different forms in this set of court forms. You're not going to use them all, but I just point out that they exist. So this form happens to be the miscellaneous. The other thing I wanted to point out is we've seen situations where there's a conservatorship and it's a husband and wife. They've been married for 35, 50 years. And then they get a conservatorship because one of the spouses doesn't have capacity, and they get pulled into the court accounting system. And I had one like that, and I objected to the attorney that set it up, because when you have all the assets being community property and only one of the spouses has competence, you do not have to do a court accounting, because that other spouse has complete authority and control to manage community property. And so this one case that we had, we got the woman out of it so she didn't have to do it anymore. And your reference on that is Probate Code Section 3051, 3054, and 3088, if you have that situation. So at this point, we're on Schedule A, page 6 of 6 for the income. So what we're going to do is we're going to bring that forward to the GC 400 sum at this point. So we're going to take the total of all those pages on the Schedule A, and we've got 43,000 of income during that account period. You'll notice there's no property received during the account period. You don't leave it blank, you put a 0 because that's an affirmative statement. Not that you forgot to use that line. Now we're moving on to different types of income on page 29. In this example, we have a sale of a house, and our carry value from our beginning inventory and appraisal is 230,000, We sold it for 250. So they're saying the gain is 19,000. Well, that's fine and dandy, but I don't think the gain's 19,000. Because when you sell property, you have quite a bit of real estate expense. But the way the court wants it, they just care about the sale price or contract price, less the carry value, and heck with all the expenses. We're going to cover the expenses in another schedule. So for court accounting, the gain's 19,000, and we'll show the sale expense in another place. Okay, so in this schedule, we're looking for a long-term care facility expense. Just list them item by item, usually from a statement from the facility. So schedules, page C. Let me just back up for a second. B. Okay, so schedule, when we get to page 1 of 1 on schedule B, that means that we have to go back to the GC 400 sum and enter that gains on sale during the period. Now we're switching from money coming in to money going out on disbursements. So the money coming out on the GC 400 sum starts out with Schedule C on line 8. So we're going to look at various forms and schedules. In first one, money going out for care home. Line form 1 of 8. Okay, now we have general administrative expenses for the ward, living expenses, in this case, the court filing fees, probate referee appraisal fees, listing those expenses. Then we get into medical expenses, just list them sequentially. And when you're listing medical expenses, it's only the copay. It's not the total amount of the bill if part of it is insured. Okay, now we have disbursements, property sale expense. This is what I was talking about. Now we have the escrow fee, termite inspection, real estate broker fee, and then a payoff of an existing mortgage loan on the property. Now the house sale has been fully disclosed to the court. In this example, we have an expense. What for? We were selling some of the Conservators' furniture, and we had a brokerage fee of 20% for the personal property broker, $500. Then we get into the rental property expenses. Notice it's separated out from the income. And I would list them by rental property if there's more than one. Miscellaneous expenses. Tax repair, IRS disbursement for tax due. For reference, some other forms that you may need or come across with your fiduciary duties. One of which is, it's not a California form, it's an IRS form 56. where you send notice to the IRS that you're in charge of the taxes. It's notice of fiduciary relationship. And then the other form is the power of attorney form, the 2848 that you would file with the IRS, stating that you have access to all the IRS records. You would file that by and attach your letters of administration. When you have a tax return and there's a refund coming back to you, and it may look like it's for the conservatee, you file a form 1310 that says to the IRS, you're going to get the refund and do the proper thing. Sometimes when we're doing taxes for trusts or estates or conservatorships, prior tax returns have never been filed. So we file a form 4506 T as in Tango, and that gets the IRS to give you copies of their database transactions for all the 1099s and W-2s and things on their computer, allowing you to access the information to meet your responsibility to fill out tax returns, which you're required to do. The other thing is when you're going through doing your accounting, I have an adding machine and a tape. I check every number with the numbers I keyed in. You want to be real careful of the data going in so that you avoid getting something out of balance. On digital adding machines, it'll show the sequence of the numbers you keyed, but it's really important to be careful so that you don't end up spending hours trying to figure out why you didn't balance. In this case, we have the sale of a car. We just take the carry value that's been on your books for a long time and have your sales price and then the gain or loss.
Do we have to add all these forms if they don't apply?
No, you only are responsible for things that do apply.
Thank you.
So that's a good question because sometimes when you're doing a probate, there's going to be out of state real property. And because it's out of state, it's not part of your accounting because you're going to have separate administration in the other state. So at this point, we've gone through all the disbursements. We've covered all the income came in, all the money that went out. And so now we need to get back to our GC 400 sum to enter what's happened here. So all the disbursements on Schedule C, the loss on the sale of the car, and so that's all we have for disbursements now. So we're moving down the GC 400 sum. Now we need to deal with the issues of ending cash balance and ending non-cash asset balance. So on page 39 is the cash account balances at the end of the account period reconciled to the date of the end of the accounting and the last four digits of the account numbers. Then we need to list the non-cash assets at the end of the account period. And those two numbers, the cash assets and non-cash assets, end up going back to the GC 400 sum. And at this point, we've gone through every line on the GC 400 sum and the moment of truth happens. Drum roll, please.
Wait 1 second. I'm sorry. So on the end of the account period, the total, do I use this page if it's only a checking account with a small amount?
Yes.
Okay, and where does that, what, is that under, do I put that balance under estimated market value or carry value?
Okay. Because you have one account and it's a cash balance, it's not estimated.
Okay,
It's
right,
actual.
yeah,
It's
okay,
actual and it's cash assets.
right.
So the form that,
Oh, this is non-cash. Okay, sorry.
yeah.
Got
So we were back on page 39 and it says, what's your cash assets at the end of the account period? Well, on March 7th, I had $40. Okay. That's all I've got. So you bring your ending cash balance and put it on line 13A on the GC 400 sum.
Got it.
And at this point, hopefully you balance. If you don't, you're not done yet. Don't bother turning in anything to the court that doesn't balance. Other helpful things, these legal forms are online, judicial counsel forms, but you can also go to Riverside Legal Aid, and they have all the accounting forms, or 33 of them, in one PDF document. That might be helpful from Riverside Legal Aid.
I know you can think I'm dumb as a rock, but probably I do. So which two lines should be so the cash assets and which two have to match up?
Oh, okay. That's a good question. Line 7 and line 14.
Better add up. All right. Thank you.
Sure. Let's see.
That was line 7 and line 14 need to add up. Okay. These two need to add.
All right. So talking to probate examiners, some of the problems people get with trying to do accounting, number one problem is they don't, line 7 and 14 don't balance. When you have expenses, you need to clarify to the court why those expenses were incurred. So if you're working with a conservatorship and you put a hot tub in their property, the court might think that maybe you're doing that for your own entertainment purposes. So you might put, the expense for the hot tub and then describe in your accounts how that benefits the ward. Another one would be an example, you bought 20 sets of bed sheets. Well, why do you supplying the neighborhood with bed sheets? No, you would write on there, explain that the ward is incontinent and it's required.
What page is that on? I'm sorry.
There's no page.
Oh.
I'm free-forming.
Oh, free-forming. Okay.
So another problem is accounting for things you have no responsibility for. Confusing other types of accounting for fiduciary accounting. And if you hire someone to do fiduciary accounting, you have to be really careful, because if the person doesn't know how to do court accounting and you pay them and the court doesn't accept it because they did not follow any of the court formats, and then you have to hire another person who does know how to do court accounting, you would probably be liable for the error of hiring somebody that was incompetent and not trained in fiduciary accounting. And don't just take it that they say they've done it. Maybe look for some references, some sample work, because a lot of people think they train you in accounting school how to do accounting for businesses. That type of accounting and QuickBooks does not It's not acceptable to the court. Another problem in assets and reporting in the accounting is listing in the equity. So if you have a house worth $1 million and a $400,000 loan, they say that you're only accounting for 600,000. That's not right. It was the appraised value. Another problem that happens is fiduciaries paying money to themselves. You have to get court approval before you're compensated. So you just don't have access to write your own paychecks. Some other types of errors and things.
Were you just telling us the general differences
What?
between financial accounting and fiduciary accounting?
No, I'm telling you errors people make trying to do fiduciary accounting. I'm not going between regular accounting and court accounting. The only reason I brought it up in that context is if you hire a vendor to do the accounting for you, that they need to know what it is. You know, Tamara does a lot of fiduciary accounting. Our office does fiduciary accounting, but not every CPA or tax preparer knows this process because it's unique. Another thing that's not in your material I want to point out to you is what do you do when you have a question? And if you do a lot of fiduciary accountings, you might want to buy a reference book. And that reference book is Fiduciary Accounting Handbook from CEB, which is Continuing Education of the Bar. The book's rather expensive. It's like over $300. And if you're trying to learn accounting and you think you're going to read this, you're going to have to guess again. It's not a reading book. It's a reference book. If you're doing a big accounting and you have a question, you need a specific answer. Another thing I want to point out in your, it's not in the material, but there's a concept called change in form of asset. And that goes on a Schedule F. What is a change in form of asset? Well, I think the most common is that you transfer money from Wells Fargo and you open a new account and put the money in Bank of America. So in the change in form of asset, you had this Wells Fargo account for a long time and it's going to disappear now. Well, why did it disappear? You would show that on Schedule F. Or if you had stock in securities and they did a stock dividend, gave you more shares. Anything in a change in form of asset would go on Schedule F. Now, let's go back and summarize again on the.
And just Rex, it's almost 11:15, so you're really pushing into my hour.
Okay, so now we've gone through all the charges and the disbursements, and I want to quickly go through two other things. In your handout number 3, it's called non-follow along handout. I've included that from a lot of court websites teaching people how to do court accounting. And then the other thing that I wanted to talk about briefly, but it's important, is doing court accounting on a computer. So it's not required to use any form except the GC 400. You can use like an Excel spreadsheet. Tamara has a special software she created to do the accounting in-house for her. We have a spreadsheet outline that we make available for $50 as a template on Excel. But in this case, the first page on this accounting is the summary of account. And you would transfer that to the GC 400 sum. Now, what we do in the beginning, we have to show the carry value, and then after the first year, we have to show the market value of all assets. And using this spreadsheet kind of accounting, we would show all transactions chronologically. This is receipts. And then we would show all transactions by category. This is income. And the same thing with disbursements. List all the disbursements chronologically, then list disbursements by category. We would
And
all
if
say,
I can, sorry, just interject. Please remember, to those who are preparing the accounting, although he's showing you the chronological by date, that's considered an informal accounting and is not acceptable on its own for court approval. It must be categorized. So although you might turn in just the ones by category by date, like the prior sheet, he said, that is not acceptable just on its own. You must also include the categories. So careful on using the sample that shows just by date range. That's considered an informal accounting. It is acceptable for trust administration, but not for conservatorships, guardianships, or probate.
okay, the last thing I want to point out, if you want this handy completion certificate that's so famous you might want to put it on your wall, email our office and we'll give you a completion certificate for the class. And with that, I'd like to turn control of this class back to Tamara Brown. So
Do we have your email address?
it's info@rexcrandell.com.
Thank you.
Yeah, it's we're in Walnut Creek and that information is all on the internet. Now I need to figure out how to turn the meeting back over to Tamara. Let's see here.
Go to me in the pictures and right click and just say make host.
Make host.
Sorry. I thought this was mandatory. This class was mandatory.
What is it? Mandatory? I'm
I
sorry.
thought this class was mandatory if you are applying to be a conservator. Am I wrong?
What court are you in? What county?
Shasta County?
I did not hear it was there. I think there was another training for conservatorship, and it was there was an online class, I think out of Riverside, that for unique that required. Ours is not required as far as I know by any of the judges. It's appropriate and helpful.
Yes, it is. Okay, great. Just need to know.
So
Thank you.
let me give the host responsibility back to Tamara, and I'll stay here until Tamara gets on. But I'm going to be, this is the end of my part, so I'll give you my closing information. If you have any questions, you can call our office, or better to email us at info@rexcrandell.com. Our phone number is 925-934-6320, and I can answer quick questions on the phone if you have something that's not takes up too much time that would have to bill for it. Okay, Tamara, do you have your material? And
No, you haven't shared it.
okay, make host. I clicked it once. Is it happening?
No, it says the host isn't allowing sharing of this meeting.
I did it before and it worked. Okay, I take on your image, I go down and it says make host. I click it. And it seems like it should because I don't have a green line around my screen.
Yeah,
Multiple.
actually, if you want to assume the share screen, you can also do Alt S on
All,
your keyboard and see if that works.
It says the host isn't allowing me to share.
I'm sharing to you, so it's going to you, not from
Yeah,
you.
you're still host. I'm looking at the participants.
Okay, I'm going to try make co-host because make co-host confirm. And that looked like it.
Yep, got it.
Okay, now let's, as you as co-host, let's see if you can share your screen.
I should be sharing. Can
Yes,
you guys see a petition?
yes.
Yeah.
Okay, perfect. Okay, I'm going to be rambling so I can get through this, y'all. Hang with me, promise. Okay, so understand this is the last part of it. Keep in mind, again, the last part. So, what I'm going to be teaching about is you completed your accounting, you balance, you're satisfied. Now, what do you do with it, right? Because you have to get it in front of the court. You cannot just submit your accounting willy-nilly, just hand it over. The court doesn't understand what that means or what you're trying to do, even if they requested you do it, right? So you have to tell the court, okay, what am I doing? So what you're going to be doing is completing a petition for the approval of that accounting. Keep in mind, very important, because once the court approves your accounting, that relieves your liability for what you did during that time period only. It doesn't relieve your liability for anything after, or it's only what you did during that account period. So we'll go through some samples. And keep in mind, say for instance, you gave a car away to a friend
What page
because,
are you on? I'm sorry to interrupt you. I don't see, can you go to the bottom and tell me where you're at?
sweetheart, I think it's page
Oh,
11 of your
thank you.
handout.
You're good. Thank you. Thank you so much.
Okay, so keep in mind that when you're asking the court, say for instance, you'll see in the sample here that we sold a vehicle or we gave a vehicle away. So realize if your vehicle was your beginning asset, right? So you took control of it, but then you gave it away. Maybe not necessarily gave it away. Maybe you sold it. Maybe there could be several reasons. Um, Say, for instance, non running vehicle, maybe it's in a storage unit. You think it's not, there's no value in paying that storage unit to hold that vehicle that isn't running, will never run, it's missing an engine, it's whatever. So you may want to try and not get rid of it, but let's say give it to a different owner, right? And you sold it or you gave it away, and the value, the probate referee valued it at was 2,000. If it was given away and there was no cash received for it, doesn't mean you did something wrong. It just means it wasn't running. You're not a car salesman. You're not going off to sell it or try to. So, but a mechanic said, hey, I'll take that vehicle because I can use it for parts or whatever. You can disperse it, and then you tell the court in your petition you got rid of it and you ask for approval from the court, or let's say a blessing from the court that you got rid of it. And then once that court accepts it, and accepts your response and signs an order, you can be relieved that later on a beneficiary can't come back and say, hey, you got rid of a vehicle that nobody told you you could, and blah, blah, blah. I want money back, or whatever the purpose was, right? Um, And so you've already approved it from the court. The court would then tell that person, I gave you ample opportunity to contest it. You did not. I approved it already, so it's proved. So just think of this now as your approval with this petition, your approval for whatever you did during that account period is what you're asking for.
Okay, so you're submitting this document along with the ones we just went over.
I will show you, sweetheart, how you will attach the accounting to this petition. Yes,
But they go
ma'am.
together.
Yeah,
Thank you.
right. So you will need to complete this on pleading paper. If you don't know what pleading paper is, please log into the internet, do a search of pleading paper. You will get blank pleading paper. All that means is it's lined along the side, and this is the paper you must turn into the court. Cannot be a blank piece of paper, cannot be a Word document, cannot be anything but on pleading paper. So you're going to start it off with the same caption. Again, my sample is if I prepared this for a law firm. So, which I do many. But in your case, this is going to be your name, your address, your phone numbers, fax if you have one, but not many people use fax anymore. Then you'll have your email address. Again, how can they contact you? You will include attorney for, your name is here because you're proper. Again, your name as conservator, as proper. So make sure you're telling the court, I prepared this document. I'm not represented by an attorney, and it's just me, right? No counsel. I'm submitting this form. You're going to want to make sure you put the county. In this case, it's Orange County, one of the most difficult ones, but I digress on that. You're going to put the county here. Typically, I do not do mine this way, and there could be a variation. So just because somebody else does it a tiny bit different doesn't make it wrong, right, or the most effective. I myself will put Superior Court of California, and County of Orange will be on the second line item below here, typically how I do it. Over here in this side, we're going to be a conservatorship of the person. Remember, person means you can make medical decisions. You can put them nursing homes, things like that. That is conservator of the person. Conservator of the estate means you control money and assets. So you will either have conservator of the person and estate, conservatorship of just the estate. It could be a state of, which means it's a probate. It could be guardian of the estate, guardian of the person and estate. So you must follow what your title is. This will be the person, right? We have the name. This is the conservatee, the minor, the decedent. You will put their name. Very important to put also known as, because of the fact that sometimes you'll have assets titled in a name that was prior to marriage or a different name. Some people have their real name, but they go by their middle name as their first name. So when that's the case, you also want to indicate that. So again, if they're using the middle name as primarily their first name, you would have their real name first, birth given name, or what they started with, what is their real name. If they're married and they've been married a while, you will use that name and not the birth name, but you will use their name. And if they also have an AKA, you would make sure you indicate that here. You're going to indicate if they're a conservatee, minor, decedent, whatever the case may be. Alongside here, you're going to put the case number. I typically separate. I do a different case number and leave a blank line, and then I will put the title of what I'm asking for. In this circumstance, it is the first account. Remember, if it's your second account, it's your second account. If it's your third, it's your third, on and on. They can go many accounts, but you have to remember, is it your first account, second account, so on and so forth. So this is the proper title, first account current, meaning this is not your final. In a probate, your petition will look vastly different than this. This is just for conservatorship or guardianship. In a probate, it will state something different because it will be your first account and final, meaning no more accounts were coming, and petition for final distribution or something else.
So real quickly, so for the first one, we're gonna write down first account, then slash current.
No, not slash, just like it's written here. First
Okay, just
account
first
current.
account. Okay.
If it's a final account, like for instance, let me give you samples where it could be your third account and not current, but final, because
Okay.
maybe this person passed away, so there won't be any more accountings and they'll close the conservatorship. Or say this person no longer needs a conservatorship. It was only temporary. Maybe they were hospitalized. Maybe something like that, and now they're better and they no longer need the conservatorship. Before you can terminate a conservatorship, guardianship, you will have to do a final accounting to tell the court, okay, I'm handing over these assets and I'm done. So please approve it. So be careful of your heading here. This is just a sample, and only if it was your first account current. So it's going to be your first account current and report of the conservator, you, and a petition for its settlement. In this case only, you sold a house, so you want to make sure you put that in the heading. So approval of the sale of a house, a car, whatever it was. Again, I'm going to repeat what Rick said earlier. You're never allowed a conservatorship fee until you complete this petition. You are never allowed to reimburse yourself for expenses that you fronted this conservatorship for whatever reason. You are never allowed to reimburse yourself until you've asked the court for approval. A law firm may never obtain attorney fees from the conservatorship prior to this petition. That does not mean that if you're using a law firm that they don't get funds from you as the conservator as a retainer or deposit. That is not the same as this conservatee you wrote the check from their checking account. It is perfectly acceptable for you to pay the attorney with your own funds and then ask for reimbursement later. So
if
what
I'm
I'm
not
talking,
asking for any of that, so I'm so sorry. So if I'm not asking for anything other than I'm just reporting what he had, do I just leave it at first account current and report of conservator and leave it alone?
that's correct, and petition for for its settlement, and then you wouldn't include anything more, huh?
Okay, thank you.
Okay, so remember your caption will kind of copy what you're asking for in this petition. And we'll go on. I'll show you as we get through the petition. So you really want this caption. You're telling the court up front before they read anything in your petition what you're asking the court to look at, what you're asking the court to approve, what you're telling the court you did during your accounting period, and If it is nothing and you just accounted, then you will only put you just accounted. But you have to remember, we will get later on where I described conservator fees. You still will put how much time you participated in this conservatorship. That would include following up with the care facility. That's going to include doing the accounting, reconciling the bank statements every month when you get them. It's going to include a lot of things, maybe delivering incontinence to the home. It could include checking up on the conservatee, making sure they're properly cared for, making sure, do surprise visit where you just walk in unannounced. You want to know that conservatee is dressed, their hair is combed, they've been bathed, they're not smelling. Maybe glance at them, see if you see any bed sores, any bruises that look odd to you. That is your job, and it's very important. You are the only one that can speak and make sure they're being properly cared for. So it's important that you do this occasionally, whether it's every 3 months, every 6 months, whatever. Take notes, keep those notes, make sure you have that you've checked on them. Don't just leave them in that home because your life got busy. Then maybe you're not the appropriate person for this. They need to know you're there, you're still caring for them, they can count on you, whether they have knowledge of who you are or not. I'm using dementia patients as an example. Make sure you document, make sure you do surprise visits, things of that nature. But we'll
What if
get
he
into
lives
more
with
of that when we get into the petition.
If he lives with me and I'm the sole caretaker, are you saying in number two that I just can state I oversee all of his care?
Yes, that's
Okay.
true. We
Okay.
will get down to that and you'll see my example as we
Okay.
get down, sweetheart.
Okay, thank you.
Okay, so you will list date of hearing. You will not really put a date here because 9 times out of 10, you don't know that hearing date. In fact, really 9.9 times out of 10, you won't hear that hearing. Even if the court has scheduled the next hearing and you turn in this petition, guess what's going to happen? The second you turn in this petition, you're going to get a brand new hearing date, and that hearing date the court already issued is likely going to be vacated, or you'll still show up for the hearing and the judge will say, okay, we're continued until your petition. So a date here you would not be putting. The court, after you file it, will return a copy to you with the date filled in here. They will also fill in the time. If you know what department you're in, a lot of times, sometimes people don't know. It's okay to leave that blank here, and more than likely the court will fill that in for you. I do not include the words judicial officer. I do not know what judge will be on the bench that day. Even though you may see the same judge every time you go, that judge can take a vacation, they can be sick, they can be called to a different courtroom because the court, maybe that judge wasn't able to come in because they were sick. There could be a million reasons why your judge might not be able to hear your case that day. So I don't even write this line item, but if you choose to, you can put this here. And what would happen is if a different judge hears the case, they will cross this out. They will put their own name, handwritten typically, and initial it on the petition. Sometimes they won't, sometimes they will. So we're starting it off. Guess what? You're the petitioner. I typically will put this name first, petitioner at the end, but do it how you wish. Petitioner, me, here I am. I put in brackets that I'm here in after, which means every time I'm referring to myself later on, I'm likely only going to state I'm the conservator. That's what you're telling the court. So if I'm using the words me as the conservator, I'm meaning this person. Okay, as conservator of the estate of Jeannie presents. Now, typically this would state, if you look, I say person and estate. This should say as conservator of the person and estate of Jeannie. That's how I would write it myself. Conservatee, you see that here, presents for settlement and allowance. His, you would write her if it's a she. Verified first account. Typically what I do is after I state present for settlement or typically I'll say present, do a semicolon, and then I'll copy this header and put it here. And then the next sentence will be petition respectfully states. What am I stating? My appointment. Please make sure your papers must stand on their own. Keep in mind, what does that mean? That means I should only have to look at this petition and know everything I need to know about this conservatorship. That means my papers stand on their own. Please, please, please do not ever tell the judge to go look for themselves or tell the judge, I've already filed my appointment. You know what it is. You can go look. Anything of that nature, you must repeat it for the judge. It's not their job to go back, even though they can. It is your job to make sure your petition is whole, meaning tells this whole story. So appointment. The petitioner was appointed the conservator of the person and the estate of Jeannie, also known as her AKA name, on March 8th. Look at this date. Does this date look familiar, y'all? We've been talking about this date all doggone morning. This is the date that's on the inventory and appraisal. Remember, this is the date you were appointed. Again, you're relisting it. And letters were issued on a different date. The reason why letters can be issued on a different date is say you have to go get a bond, say you have to, there's so many other reasons that your letters can be issued later. But again, it's all about the state appointment. At all times, you have acted as the conservator and you state there has been no break in a chain. So now we're getting down to number two. Number two is inventory and appraisal. I am stating that an inventory and appraisal was filed with the court on this day. And what is the value, the total value on my inventory and appraisal? It is this. What's going to happen is the probate examiners and or the court judge itself can go back and make sure your accounting, your beginning cash assets will be this number. They can also go back to make sure that what your accounting follows this number. If it doesn't, they will reject the entire accounting and tell you it does not match. In the footer, I usually put what it is. Typically, I'll take the first couple words. I myself add a whole lot more. I will put the name of the conservatee. I will put a case number down here below and typically have page number so that it follows a page number.
Excuse me. Okay.
So one question. So you're saying the showing the value of the state. What line does that come from on the GC 400?
It's not the GC 400, honey. This says inventory and appraisal. So if you remember the inventory and appraisal, let me slide up.
Oh, so if I don't have one because he has nothing that needs to be appraised, then that's zero?
Yeah, but you have not a dime of cash and not a nothing.
Yeah. So, but I thought the account. So what? So is that the total property at hand at beginning of account line 1? I'm just asking what line it comes off of on
This line right here, the inventory and appraisal line on my.
okay, that's what I wanted to know. Thank you.
Sorry, I don't mean to make you dizzy, but
No,
I'm going
fine.
down to the next page. Okay, so next you're going to tell the court what is the period of your account. So you're doing your accounting. It's March 8th through March 7th. That's a year. Again, I'm probably going to repeat what Rex said. For conservatorships, your accounting's due the first year after appointment. After that, it's every 2 years, unless you turn in your first accounting and the court states, I think Rex, you're not muted again. I'm hearing a bunch of backgrounds and you guys mute. Okay, so remember it's due the first year, unless the court tells you that you do have, they want to see the next one in a year. Sometimes they will do that. Otherwise, again, it's due the first year and then every 2 years after that. If you don't turn it in, more than likely you're going to get what's called an OSC notice from the court. OSC means order to show cause on why the court should not remove you, or why the court should not sanction you, or why the court should not take any other measures for you not following the rules of court, which is your accounting's due in a specific time period. Again, when you're ending 1 year, don't be panicked. You have to do it that very second. The court will give like up to 60, 90 days for you to do it because you're waiting for bank statements, something like that. So please don't panic about that. But
Do we have to submit a separate petition for the inventory and appraisal as well as the first year's accounting?
honey, no, it's all right here. So you submit first your inventory and appraisal. That's submitted way long before you even do an accounting. They're two different time periods. So
So I submit that the inventory and appraisal doesn't have its own petition. I just submit it by itself.
absolutely, you're correct. You just submit it by yourself.
Okay.
Well, wait a minute. Doesn't the probate examiner submit that? Isn't that where it originally comes from?
No, ma'am. The probate examiner returns it to you. You sign it, and it is your responsibility to file it with the court.
Okay, so it is.
Never the examiner.
So who initiates the inventory? Is it you?
You initiate the inventory and appraisal. If you have attachment to assets that you need valued by the probate referee, you mail it to that probate referee. And then once they've done their job, they mail it back to you to sign and file it with the court.
So all of this initiates with you.
You, not me, but you, yes.
Yeah. Well, the person in this position.
Absolutely. Yes, honey, you're right. Yes.
Thank you.
Uh-huh. Okay, so we've listed our account period. Again, remember, this might be 2 years worth. It might be also the other thing that I try and do, and it's perfectly acceptable. I don't like my accountings to begin and end in the middle of a bank statement period. That drives me bonkers. So I typically would take this and say March 8th, 2012 through March 31 of 2013, so that my next accounting period will start April 1 and will continue until the end of a bank statement. So it would be like April 1 of 2023 through, remember, I'm going 2 years now, March 31 of 2025. I'm sorry, 2015.
Okay, wait a minute. Okay, so I'm confused. I thought
Okay,
that we were doing this from the date that we first got it approved.
that's
So,
correct. So that date does not change. I'm talking my end date. My end date, I might not do exactly 1 year at first. I might do 1 year in a couple of days because I want
oh,
it to end at the end of my bank statement. So I'm
okay.
not trying to figure out my balances in between a bank cycle.
And then you said it might be 2 years worth, but why would it be 2 years worth? I thought if we did it every other year, it would be the year you filed first and then whatever's going on in the third year. Or do
One
you have
more
to
time,
account for both
sweetheart.
those years?
One
Huh?
more time.
Okay.
On a conservatorship and a guardianship, your first accounting is 1 year's worth. Where that's here. Your second accounting is going to be 2 years worth. So again, your second accounting is going to follow and it's going to start if I'm using only this period. Ignore what I said earlier. My next accounting period is going to start March 8th of 2013, and it's going to continue until March 7th, 2015, right? That's 2 years.
So
I'm
there has to be 2 years worth of bank statements and accounting for that to be done?
absolutely, sweetheart. That's your
Okay,
second one.
but you said on the first one, it doesn't, you don't have to go backwards. You would go from the very, like for whatever's going on at that moment with that bank statement, that's the first one. And then the second one's gonna be the 1 year, or I mean, the second one will be from that date to the next date for 2 years. So all
Correct.
that accounting, all those receipts and everything for 2 years?
Absolutely. And you will
Okay,
continue doing this the lifetime of the
okay,
conservatorship.
okay,
The lifetime. But
okay.
again, please don't let me confuse you. I'm only stating that my ending period, say for the first one, I will continue till the end of I've included 1 full year, most definitely. But again, I'm probably a year and a couple of days because I want it to go to the end of the bank statement because it's easier for me, especially going forward all the years.
Okay.
So it's only my ending date I'm changing. I'm never changing the beginning.
Okay.
Except for now, when I do my second one, if I ended it March 31st on 2013, my second one will start on April 1. It won't start on March again because I've already included it. Do you need Paula, honey? I've completely confused you.
Okay, you're good. I don't think I'm gonna have to do all this anyway because he has so little money. So
Okay.
go ahead.
And again, sweetheart, you can take this class as many times as you want. So once you get yourself into doing this, you might have more knowledge later to where you take the class again later, and this
Uh,
really starts making a whole lot more sense
okay.
then. Okay, charges and credits, we went through that on the GC 400. So you're just saying this statement, you can copy this statement. Authorized investments, you have invested in interest bearing accounts. This is so very important that you make sure that when you get appointed, you change every single bank, savings, whatever account to make sure it's interest bearing, even if your conservatee did not have it set up as an interest bearing account. What does that mean? That means that that account will get interest every single month, whether it is a penny or it is $500 or what it is. Let me tell you a quick example of what happened many years ago, many years ago. Conservatorship. They left the account in a non-interest bearing account. The account had money in it. Let's say, let me use the example, maybe $200,000. It did not gain interest at all the whole time the conservatorship took place. One of the beneficiaries of, because she ended up passing away, the person that was conserved, one of the beneficiaries petitioned the court and said that because the conservator did not have the money in an interest bearing account, they, as the beneficiary, lost thousands of dollars through this process, this however long the conservatorship took place, lost thousands of dollars in interest that they would have inherited had the conservator had the money in interest bearing account. Then what happened was the court then charged the conservator out of their own funds to reimburse or pay that beneficiary the interest that that account should have earned had they been responsible and put the monies in interest bearing accounts. Also, what will happen is if you state here that you have it in an interest bearing account to the court, and they go to your accounting and look at your income or your receipts, and they don't show any interest you've received, the first question they're going to ask you is, did you tell a fib on this petition that you had it in an interest bearing account? Because your accounting does not show interest. So there are many ways for the court to know what you're saying. Remember, you're signing this under penalty of perjury. That means a whole lot to the court. That means to the best of your knowledge. That means everything. So please do not state it's in an interest bearing account if it is not, because it's very easy for someone like me who's reviewing an accounting, say I'm on the side of the beneficiary, or a law firm or anybody else, to tell whether stuff was in an interest bearing account or not. Okay?
Quick question along that line. If there's a property that you're managing and the property gets burglarized, are you responsible for the safekeeping of that property?
Well, here's the thing. Yes, you are responsible 100% for everything in that house or real property. It is your responsibility, once you are appointed conservator, to go to that house, put up cameras everywhere. You will be reimbursed for those cameras. Get yourself a subscription to where you can look at inside that house at any time. The very second you may see, which is very common all through California, is squatters get in. When squatters get in, typically they will remove walls. I've seen them remove hot water heaters. I've seen them remove ceilings. I've seen them remove toilets and sinks and stoves, and they absolutely destroy a house. It is the very second you see activity on a camera, call the police, get them out of there. Don't wait till they've already been there, say a week, 2 weeks, a month, or whenever you discover it, because then you have to go through the whole eviction process and explain to the court and blah, blah, blah. Remember, you are responsible to turn over to the court or a beneficiary that asset in the exact same shape as you obtained it. Maybe you did upgrades, like the conservatee lived in the house, so maybe you upgraded the bathroom to be bars in the shower so they could shower, or maybe you changed the tub to a walk-in tub, or maybe you swapped out carpet and put in hardwood floors so they can roll their walker or whatever easier, things of that nature. But you do not want to get in a situation where a squatter comes in and completely destroys that house, because more than likely you're going to be held responsible. So it's very important. My thing, I always state, get cameras. Make sure you have a camera everywhere, garage, outside in the backyard so you can see the backyard, inside, everywhere, kitchen, living room, front door, garage door. Make sure upstairs so you can monitor. Now, this doesn't mean if they're living there that you really want to invade on their privacy. I am not saying that whatsoever. Keep in mind they are entitled to some privacy, but that might help you because what if they fell and maybe a caregiver wasn't there or something? You might be able to see that by watching the cameras, or there's a million things. Cameras are amazing. It
Oh,
might be a cost up front to you, but what it'll save in the whole time is going to be worth its weight in gold. So please, please, please do that. But I'm going to move on because I got 3 minutes. I told you I was going to go over. So statement
well,
of
please
line,
go.
I'm sorry.
Please continue.
Okay, statement of liabilities, you're stating if there's any liens on the property. For instance, somebody filed a lien and it's owed, maybe property taxes, it could be on a possible foreclosure. It is your responsibility to catch all that up and make sure it's right. So please make sure you take care of the assets. Don't say that, oh, they were behind before I even got appointed, so it's not my responsibility. Yes, it is. That's what you signed up for. Okay, sample, we sold an automobile. You will put on here that as conservator, I sold the conservatee's automobile. I had it listed on attachment 2. I sold it for a loss, and that's all within your accounting. And hold on 1 second, I'll be right back.
Responsible.
I'm so sorry. One of my alarms were going off in my house and I couldn't figure out what it was. Okay, sale of furniture. Again, would be if you sold furniture. In this case, they sold furniture in the vacation home because they were selling it. It wasn't needed. In this case, they went through an auction company or a private person. I'm going to tell the court what it was appraised at, what I paid that auction company, or say I donated it because it didn't have value. Say I gave it to family members because they wanted it. It could be whatever happened in your situation, you will put the details there. Then you're going to go to, in this case, we sold real property. I'm telling the court I sold the property. I sold it for a gain, which means I sold it for more than its carry value. I have it on whatever schedule the schedule is for the gain. And it was court confirmation. Again, remember, before you can sell a house in a conservatorship, you must have court approval and the court must confirm the sale. So it's very different than if it was your house or a probate. You must get court approval before you sell a home. Additional bond, you're indicating to the court. Remember when we marked the bond insufficient or sufficient, you're indicating to the court you have a bond in place, what your bond amount is. In this case, because cash was received from the sale of the home, I will indicate that the bond needs to be increased, or you can go prior to the court ordering you to increase the bond and you can increase the bond yourself. I don't see this happening ever. I only see that indicating to the court that you have more money now, and when the court issues an order, they will issue you to increase the bond.
If the bond is sufficient amount, do we need to even mention it or just omit that?
No, 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 no. Always You may not say additional bond. You may only say just bond, and you'll state that currently the bond amount that is active is 20,000 and it is sufficient.
Got
And
it.
that's your only wording. But you want to make sure if you don't say something about the bond when you turn this in prior to the court approval, you will get examiner notes, and likely the examiner will ask you for a supplemental declaration, which would be another kind of answer to notes, where they will state that you need to talk or mention something about the bond because you did not. So when you get notes like that, that's your cue. Oh, maybe I accidentally left it out. You typically have time, depending on the county you're in. I know I'm talking LA specifically. Down in LA, LA, San Diego, they give out examiner notes about 2 weeks prior to your hearing date. So you have 2 weeks to answer their questions and turn in a declaration before your court hearing, or otherwise, there are other courts like Riverside might be one of them, Orange County might be another. There are some courts you get your notes after 4 o'clock the day before your hearing. So you have absolutely no time to answer. Contra Costa's a little bit early also. I think they're a week to 10 days. So depending on your court is depending on when you'll get your examiner notes. So watch for those also. Okay, moving on. Again, also, let me say, if you, in your petition, you did not sell real property, please don't include this statement about real property. If you didn't sell furniture, do not include this statement. If you didn't sell an automobile, do not include this statement. But let me be very careful, because I've done this in prior classes when I state that this. People have turned in petitions to me and said, Tamara, it got rejected. I don't understand why. And they didn't include many other things on this petition that have to be included. When I say what does not need to be included, it are these little things like selling an automobile or furniture or property. Everything else must be in this petition to get it approved. So let's move on. No affiliate relationship. Very important. You must state whether you hired a family member and paid, keyword, paid them. Now, it is not illegal. It is not wrong. It is not a bad thing to hire a family member to help you. Give you a quick example. You need to sell the house, and your husband or wife is a realtor. You want to use him or her. They will charge the same commission fee that it would if I hired any other realtor. So I want to use my family member, right? Nothing wrong with that. Just state it. But you need to add a little bit more, stating their commission was the same amount I would have paid somebody else. Another one would be, say you had to have a landscaper because you're in an HOA. Your landscaper goes on vacation a month. I hire a family member to go do the landscaping. As long as I pay that family member the same amount that I paid the other landscaper or lower, there's nothing wrong with that. The only problem that comes in is if I pay a family member more money than I would pay another person in the same profession, then you have problems, because the court will come back and say, guess what? You're paying back the conservator the amount you kind of abused. They might not use that word, but it'll be in the lines of that. Make sure you make this statement known on your petition. Next is the compensation. Again, the only time you can accept compensation is by asking for it through the court. In our example, we state the conservator has spent over 150 hours providing services to the conservatee, who is the mother. He visited the care facility how many times, managed the assets, paid the bills, was very frugal. Court loves this word. Very frugal in managing the money. So they were penny by penny, making sure, if they paid a bill, it was the proper amount. They arranged for the sale of the automobile. They drove, they cleaned out the property. They did all these things. The conservator has not received any compensation for his services. In this case, the conservator requests $500, which is a reasonable and normal amount, or you would say conservator waives compensation, meaning you are not asking for compensation. Please let me tell you that typically Contra Costa County had a very beautiful local court rule, and I seem to find it occasionally and sometimes I don't, but they had rules on how much a conservator could charge for the hourly rate. It did increase from when I first started. So when I first started, it was 50 an hour. I think now it's increased to 75 for a non-professional fiduciary, which is what you would be. If you're a fiduciary and doing the same time to work, the fee is much higher. Even though it increased to 75 an hour, I like to hold back and only do 50 myself. So, or I like to suggest 50 is a very nice, reasonable nominal amount. I've seen it approved over and over and over again. If you start going higher than that in your hourly rate, you should have an explanation of why you feel it should be higher than that. And then again, it's up to the court to approve this amount or not. So you will, if you're going to request time, you're going to turn in a timesheet. So typically I'll write in here C exhibit, and it would be 2 because my exhibit number 1 is going to be my accounting. And I'll say, here's a copy of my timesheet, which says everything I did, how much I charge per hour, and what reimbursement I request. You are not obligated to not collect. Nobody has asked you to do this for free. It's a lot of work. You're entitled to compensation. Say you work 150 hours, you times that by 50, right? And you feel that amount's too high. You can ask for a lower amount. You can say, although my hours are 150 and the reasonable fee is 50 per hour, I really only want 500, and I think that I'm fair and entitled to that amount. So you can do that also. Again, you'll either put an amount or you waive an amount. So it's going to be either or, but this statement will still stay within the petition. Attorney compensation, that will stay also, regardless if you hire an attorney or not. In this example, an attorney was hired. The only time an attorney can be paid, again, through a petition and an order from the court. If you did not hire an attorney, there's nothing wrong with you stating conservator did not retain the funds of legal counsel, there wasn't enough money, wanted to do it yourself, whatever your reason being, you would state that here. Otherwise, you're going to have to ask for reimbursement. That attorney will complete this petition anyway, you wouldn't, and they will attach a copy of their timesheet. We're almost done. We're almost done, promise. Veteran benefits, you must also state whether or not the conservatee was receiving money from the Department of Veteran Affairs. Again, if they were not receiving money, indicate it. If they were receiving money, indicate that. State hospital also must indicate, it must be on a petition. You're either going to indicate they were a patient in a state hospital under the Department of State Hospitals or Department of Developmental Services, or they were not a patient. So you must state either they were or they were not. Conservatee's address, I, in a petition like this, do not necessarily state unless it's like a care facility. I'm fine with that. If they're at their home residence, I don't want somebody knowing that a conservator who usually they're frail or, they just can't fight off ugly people. I don't want everybody knowing where they are. So I might just say to the court, they're at the conservatee is at the same address as when the original petition was filed, or they haven't moved, or something of that nature. And that's the only time I may not state the conservatee's address. But again, when you're talking a facility, they have their safe, you have to sign in at the door. Sometimes there's somebody monitoring who you're going in to visit. They have their own safeguards, so I'm fine with listing it. But if they're at their own home, if they're at your home, whatever, I don't like stating that all the time or ever, really. Account statements, we're getting down to it. I'm telling the court I'm going to submit separately. Separately. Keep those words in your head. Separately. I'm going to submit the bank statements that match the accounting. You must submit original. Let me say that word 100 times. Original bank statements. You cannot print them off the internet. That is not original. If you print them off the internet or only have internet access, it is your responsibility to go to that bank, make the bank print copies, and the bank must sign or stamp the back of those copies that they were originally printed from the bank, so that you as a person have no way of manipulating what those bank statements say. I can tell you, I can take any PDF and kind of manipulate it to how I want. The bank wants to make sure what they are receiving are original bank statements. So when I say original, I'm talking original. So if you don't get bank statements mailed to your house, make sure you're going to the bank and having the bank certify the bank statements they are printing, not statements you are printing. Okay, there is a separate cover sheet. So if we have time or people want to stay on, we'll go through that. At the beginning or for your first account, your bank statement must be every single account listed from every month of your account period. And then after the first one is approved, the court typically, and I'm not guaranteeing this, it's dependent upon the court itself, they typically will only ask for the beginning bank statements and the ending bank statements, because they want to make sure that the balances at the beginning were that amount and the balances at the end were the amount you stated on your GC 400. Capital changes have to do with annuities, mutual funds, equity accounts, stuff like that. So if there have been major changes to where, say, there was a stock split, or say you moved from one investment to a totally different investment firm, and your carry values change from when the probate referee valued things like that, this is where you would indicate it. Statement of liabilities, you could indicate if you know, you might not know, but if there's a mortgage held on the property, You would want to state what the mortgage balance is, what the payments are, maybe the rate if you know it. I don't get this detailed usually because I don't know it most of the time, but state as much as you can. Request for special notice, very important, and please keep in mind, and again, we only have one more or three more pages, but very little data, so I'm almost done.
I have a
Request for,
regarding the banking.
yes, son, go ahead.
Okay, so they only have to submit the first and the last bank statements. However, I'm just questioning, what about the canceled checks that actually prove who the checks actually were paid to?
No, not necessary.
Okay.
Tony, sometimes they're on the back, or some banks have printed the checks on the bank of them. You would turn that in if it's part of it, but unless the court asks for a receipt, and occasionally they do. Let me give you one where it was a probate case I just did, and the probate administrator paid fast track $457. Now it was owed, it was back owed, but the court said it doesn't cost $457 to cross the bridge, so they wouldn't accept that and said the administrator had to pay back that fee. What that took then was for the person to gather a receipt from Fast Track showing that all the Fast Track charges occurred prior to the death of the decedent, and therefore it was a proper balance owed. And once that was turned into the court, then they accepted that as a response. But the court can ask for whatever they want, keep in mind. So you never know when they're going to ask for a receipt or not. So you want to make sure, again, you're signing this under penalty of perjury. If you are dishonest anywhere within the accounting, more than likely someone like me, if I'm reviewing it, somebody like an attorney, the court, the examiner, one of us is going to see something that looks a tiny bit odd or different or not what we usually see with these type of accountings, and therefore you will be asked for a receipt. So please keep track of them, but you do not have to turn them in. Okay, back to special notice, very important. Anybody, and I'm talking anybody, I don't even have to be related to this case. Anybody can, for $40, 40, that's it, $40. I can file something with the court and tell the court that every single time you file a document with the court, or every single time the court issues a notice that something has to be done, I receive a copy of it. I could do it for any reason whatsoever. I don't even have to state why I'm asking for it. You will get notice when somebody files this request for special notice. You see it a lot with franchise tax board when the conservative owes back taxes. You'll see it a lot with some people in probates who take inheritance advances. You'll see it a lot when a debt collector or somebody, a creditor who maybe you have a credit card account and it defaulted, they want to know. You'll see this happening. You will get notice. They will tell you who they are and their address. So that means every single time you file a document, you have to copy them or provide them with a copy. And so it's important for you to tell the court whether or not a request for special notice has been filed on your case. You may indicate, no, there isn't one. The court can come back and say, yes, there is. We had one filed by this person on this date, and you'll have to correct your response, something like that. Now we're getting down to the prayer. We've told the court everything within that.
I'm sorry, just one second. So when you say there's no, so I guess I misunderstood. Special notice. Am I asking that if there's anybody wanting something that
No.
I want it? Is that what you're
No,
saying?
somebody has to know that, say you're a conservatorship, say you're in a conservatorship and I'm your gardener. Let's just say I'm your gardener and you owe me $5,000 because you haven't paid me because you just don't understand. It's the conservatee, right? So they owe 5,000. You become now the conservator and in charge of the money, and you're stating, well, I don't really have 5,000. I don't know if I can pay you right now, whatever. That gardener can file a request for special notice. They can file a creditor claim. They can file all kinds of stuff with the court that says, hey, until I'm paid, I want to know everything that's going on, because if I see an accounting and you're paying a lot of other landscapers or other people and you're just not paying me, then I have something I can put in front of the court or something. So it's for another person who just wants notice and wants to make sure they're aware of everything you're filing. So again, you're going to sell a house. I'm franchise tax board. I know you owe back taxes. I'm going to say, whoa, sweetheart, I know where I'm getting my money. I'm going to escrow. I'm going to file something with escrow that you owe me money. And before you get a doggone penny, guess what? I'm going to be paid.
Okay, I'm just asking if I'm stating that there is no request that I know of, or am I saying that I want to be told about any special requests?
No, you're stating whether one was filed or not, and
Okay,
you've
that's
received
what I wanted to
notice.
know. Okay.
That you've received notice of the filing.
Okay.
Okay, we're getting down to prayer. What am I asking the court to do? Now we're down to it. I told my story. I said everything that happened. Now, what do I want the judge to look at or do, right? So I'm going to state, I want him to approve my accounting. First thing I'm asking for. Typically, I will say that this accountant report dated March 8th, 2012 through March 7th, 2013 be approved and settled. So I'll put my account period time here. I want all the acts I did approved. I sold the vacation home. I got rid of the car. Not got rid of. Furniture and fixtures are no longer there. That's what this means. I don't have to restate that, or I can, but I'm just saying, court, I want you to approve. I received the income. I distributed and paid bills, stuff like that. I might also specifically want the court to tell me that it's okay that I sold the vehicle, confirm it. I want the court to confirm and approve that I sold the furniture, even though it might have been a loss, maybe it was a gain. I'm going to state that here. Then, upon settlement of this, so now, Your Honor, you've approved all I've done. I also want you to give me permission to pay myself $500. Remember, back up in the conservatorship, this person requested $500 reimbursement. Again, if you're waiving, instead, what I would write here is conservator waives compensate, or I might state conservator is entitled to compensation but waives it, or something like that. Once you waive, you cannot go back later and say, oh, I changed my mind. I think I want money now. No, once you waive it, court approves it, it's waived. You're done. But that's only for that account. You might waive compensation first account and ask for compensation second, third, fourth, fifth. You're perfectly able to do that. But you want to state here whether you're waiving or, Your Honor, I want you to approve me writing my check to myself. This case, there was an attorney. Again, no attorney, nothing's written here in this example. So attorney wasn't, in this case, attorney was hired, authorize and direct me to pay this attorney. Again, leave it out. Do not mention it if you did not hire an attorney. Now, lastly, what you're going to sedate is, Your Honor, I give you permission. Here I am telling the court. My only time I can tell the court anything to do anything is I grant you my permission to do anything else you wish to do. How lovely of me, right? It's, Your Honor, if you want to add 12 other things here, you go right ahead and you add 12 other things here, or 2 or 1 or whatever. Basically, you're just writing, I give you permission to add whatever other relief you wish. It's going to be dated. Now, I don't end my petitions this way either. If you're just the conservator, you'll just sign here, delete this line. If you are an attorney preparing this, instead of being here, this line will go up here and your conservator will sign on the verification page. So again, you will sign, no attorney, you're going to sign here, but you're also going to complete the last page, which is a verification. You must have this verification. This verification, you can copy it word for word. It says that you, the conservator, now, oh, I'm sorry, maybe make sure you're a conservator. If you're a guardian, do not copy word for word. You will state, I am the guardian, or I am the administrator, I am the executor. Don't state word for word. So in this case, you're the conservator and you're stating, I declare under penalty of perjury under the laws of the state of California that everything I've said in the petition and everything I've reported in my accounting is true and correct to the best of my knowledge. If you are lying at this point, God forbid, hon, because we're going to figure it out. You're going to be sanctioned. You're going to be removed, all those things. Please, we know nobody comes into this really intentionally wanting to be dishonest. So I'm only really joking when I say that, because I've never seen where, maybe a couple of times where they signed this and they were very dishonest in their accounting. But that's a judge's case. That's nothing to do with me. You will date it and you will again sign it as the conservator. Now, one last 2 pages before I continue on. It's not in the sample. I will create a completely blank page till I go down to line 25, and I will center, and in big letters, I will say Exhibit 1 or Attachment 1. And that's all that will be on the page. Then I will do a second page if I need an attachment 2, because what will happen is you're going to take and print this entire petition with the exhibit page being there, and you're going to attach your accounting, every single page of that accounting, including the GC 400, you're going to attach it behind that exhibit 1 page. If you're asking for conservatorship fees, right, then after the accounting, you will have another blank page that says Exhibit 2 or Attachment 2, and you will attach your timesheet behind that Exhibit 2 page. Remember back up in the petition where I showed you for the timesheet, where is it? I state at the end, see attachment 2 or see attachment exhibit 2. I need to include that page for the court and attach my timesheet. And that's it. That's your petition. That's how you will turn it in. Now, one more page. We've got one more, promise. is your blank cover page. Again, use a blank template or same page as there. You will put your name up here, attorney for, again, follow the same caption. This is where I was stating how I do my top part, where I have the court and I have the accounting, and then I separate the case from the title. But again, you will follow the same caption with your case number. But on this one, you will state original bank statements for my first accountant report as conservator. I don't necessarily, you can put hearing time and date if you know it, but you may not know it at the beginning. And then I do a few things differently. I will put original bank statements here, and I will list Wells Fargo, Bank 1234, Bank of America, 4567, my annuity accounts. I will list the bank statements that I am attaching, and I will list the period that I'm attaching so nobody gets confused and says, oh, hey, I see your cover page. It was the bank statements, but you have 5 accounts on your inventory and appraisal and your accounting, and you only attached 1 account. Where are the rest of them? I specifically state what statements I'm attaching here and then put it on the back. So I even know what bank statements I'm supposed to put behind this. Now, when you file this page as your cover page on top of your bank statements, the court automatically knows, and typically I will even include big words on top of here that say confidential. The filing clerk knows that when I turn something in like this, it's confidential. And again, it's sealed. No one else can look at these bank statements. You should keep a copy before you turn them into the court, but your copy's the copy. And so you have a copy of those bank statements also, but after the accounting is approved, the likelihood of you being asked anything on those bank statements are null and void. They won't do it. It's approved and it's done. And that's how you do an accounting from beginning till end, with submitting to the court all that you need to submit. Again, you'll get a hearing date. You'll have all the notices, because then you have to print out once and you give notice and you give every beneficiary a copy of your petition and all your stuff, all your accounting. They're allowed to review it. They're allowed to complete a declaration to the court that says they think you're wrong or you're overspending money, or why did you spend money on this? Why did you do that? The court may ask you to answer those questions for the beneficiary, and other things can happen after the fact. But again, for completing an accounting, that is all the steps that you will have, except for lastly, once you go to your hearing, you will need to prepare an order, which is a little bit different, and we didn't have time to go through it in our class, but you'll prepare an order that the actual judge signs. Once you get that order, you sit free and happy for 2 years and collect your data and just get ready for working on the next one. Now, lastly, before you all leave, I put my contact information in the chat. It is my email address. Typically, what I do for the court is, say, for instance, you cannot balance, or you have a pretty simple question that only takes a little bit of my time, or say you're nervous, or say, can you just glance at this one thing? Am I in the right direction? Or I can't balance. I can't tell you, because I'm not an attorney, what schedule you're supposed to have that specific item on, because I can't give you tax advice. I mean, I can't give you legal advice, but I can tell you ways, like maybe you should look at this, or if you ask me, should the car be on the accounting? I can't tell you yes or no, but what I may ask you is, was that car an asset when you started the conservatorship? Your answer of yes is going to be what my answer is without me even saying that's my answer. So
Oh.
keep in mind that I may give you answers that don't necessarily tell you the exact answer, because I cannot do that. But it will give you an idea of what I'm trying to tell you. So if you ask me, should a car be on an accounting? And I say, was the car on your inventory and appraisal, or was that car an asset when you began the conservatorship? And you say yes, I'm going to remain real silent, because that's going to be my answer also. But I'm not giving you legal advice, and I didn't say it. You said it. So there are ways I get around this. So if you need anything, please feel free to either come back, take the class, shoot me an email. I'm usually very responsive unless I'm out of the office or working on things. I work on very high level accountings, like one's probably beyond what you're doing. I work on $1 million can go up to $30 million estates. They're very complicated. But I do work on simple accountings also. I also, again, am hired by many law firms to review accountings. Is there anything I see that is unusual, or I might have a question about? So I do that also. So I can be busy at times that it might take me a day to answer your question, but I do respond to my emails and try and help you as much as possible. But again, you're free to take the class as many times as you want. And with that, I'm ready to end. Sorry I talked so long, but are there any lasting questions? You will be possibly asked what you think about the class. If you have any recommendations, keep in mind, you may say, we didn't go through every example that matches your situation. That's because we only have a small amount of time and cannot cover every single aspect of court accountings. But that doesn't mean the class is, not worth anything, or something like that. It truly is an introduction class. I'm here to give you the confidence to try it, to do what you can, but that does not mean you have to do it. If something happens and it's just beyond what you can do, hire somebody else who knows how to do it so that you get it done on time. But I encourage you to try it and see how well you do on your own. And try it yourself, because you might be so pleasantly surprised. You're going to pat yourself on the back and have an extra donut or cookie or whatever it is and love yourself because you were able to do it.
Tamara, quick
Yes,
question. What
yes,
software should we use?
that's up to you, sweetheart. I stated at the beginning, there's many software programs out there. Let me quickly state, if you're like a law firm, CPA firm, you want to do it for many other people. That's different than doing one for yourself, or for your conservatorship. I've tried many programs. There's not a whole lot out there. They're extremely beyond expensive, even for me. And I do a lot of accountings. They are just so expensive. Plus, I could not figure them out. They are not user friendly. And I've done countings for a long time. If I can't figure it out, good luck, sweetheart, as somebody else doing it. But people use them. But there can be very expensive. You can start off doing Excel. I like to tell people start with schedules, the blank schedules, and do it that way first until you're comfortable, and then venture off to software. I myself will tell you, I paid somebody to create a software for me. I will tell you, I cannot sell that software to anybody else or allow anybody else to use it, for the simple fact that, one, it's not originally, yes, it is my creation, but I had somebody else, another developer, do it for me. But also keep in mind that it works for me and it works perfectly for me. But if I was to sell it or let somebody else use it and it didn't work for them, and then they're shooting me emails that I don't understand because I don't know software, and then I've got to figure out to get a hold of my web guy and get it corrected, it would be a complete disaster, and that's what my day would be. So I will tell you, I cannot sell my software. I do not sell my software. But because of the fact that I do so many accountings, it was just beneficial for me to use, to have software created for me. Again, it just has to do with what does it do for me. And again, I knew what I wanted from software, so I specifically had it designed my way. I know that really didn't tell you, sweetheart, your answer, but good luck. I mean, I think the CEB or has software, again, really expensive. I think it's 3,000 a year or something for it. It's an add-on, so you have to get their whole software and then the add-on. I haven't tried to use it, so I don't know if it's good software or not. But there's something called Total Trust. I tried. There might be others, but I've tried a few others and they were just way too difficult for me.
So
But
you said start doing the schedules and to use Excel.
start doing the schedules to get familiar with what expenses go what on what schedules. And then once you're confident that you know how to complete schedules, you might move to the Excel format and complete it on Excel.
Got it.
Any other questions? Any other helpful ideas before we close down the thing? Thank you guys so very much for attending. It was a big class. We do this about every 2 months. We do not have a 2026 schedule out yet because, we had to get through this class. Likely it will be in January. We won't do anything November or December because of the holidays. Likely it'll be January. And then keep in mind, because Rex and I both do tax, or I don't need to tell people I do tax, but he does tax. Let's just say that. And we're extremely busy February, March, and April. So we'll typically do a skip February, March, and then we'll do a class right after the April 15th deadline. That's typically how we've done it in the past, but we will put that schedule together. And just remember, just follow up with the law library, sign up, retake the class as much as you want, and go from there. And again, contact me if you need any assistance. But again, please don't say 12 different things I have to answer because that would take me way too long. It needs to be simple questions that I can just quickly answer and then go forward. Any other questions, comments, goodbyes, hello, I gotta go have lunch. Anything? All right, guys, thank you so much. I'm gonna log off. And I wish you the best for the rest of the week, the month, the year, and wish you great success in your conservatorship.
Great. Thank you.
Thank you.
Or probate or anything else. So thanks so much, guys. All right.
Thanks.
Take
Take
care.
care.
Bye-bye.
Right. Bye.